Good morning, ladies and gentlemen, once again. You're welcome to day 2 of the Banking Law Symposium. We're still here at the Banking Institute at Buganda Road. And just like yesterday, today we have a very interesting lineup of events. And we do encourage you, our audience, to stay alert for the speakers that we have lined up for you today. As you might recall, we had our day 1 yesterday, where we had a range of, yet again, interesting topics. And I will begin off by giving a recap of the speakers' presentations yesterday, for those of you who might have missed yesterday's speakers, and then we will launch straight into today's program. Yesterday, we had a lineup of several speakers who talked on a range of topics. And the first speaker was speaking about sustainability in the financial institution. And they were key to highlight the Sustainability Standards and Certifications Initiative, which was launched by Bank of Uganda. This is a global movement towards renewable energy, towards green energy, climate change, and all aspects to do with sustainability. You might also recall that the speaker highlighted that sustainability involves ESG, but also involves corporate social responsibility aspects. So things of giving back, corporates always are required to give back to the environment, to the society that they serve by way of corporate social responsibility. So the first speaker did hint on the different requirements for certification under the Sustainability Standards and Certification Initiative. And he did highlight that some banks have already jumped on board. I think a couple of those were UDB, Postbank, and a couple of banks that he did mention to have already joined the initiative. And he also discussed extensively, of course, the benefits of joining this alliance and why there is need now for a discussion on sustainability, especially during events, rather pandemics, like what we had previously, COVID-19, and situations of crisis that we will need to emerge from as a financial institution, and sustainability is the way to go. Then we had a second speaker who discussed the legal dimensions in electronic fraud and how we can protect core banking systems. They did highlight the prevalence of fintechs and what is going on in the banking industry. There's a lot of innovation happening. I think that the key takeaways for this presenter was that both the bank and the customer need to be alert, because the duty does fall on both if we are to follow the recent judgment by Justice Mubiru. But also importantly is to identify those red flags when you detect fraud. The red flags being those phishing emails, if you get unsolicited requests to log in, and everything of that sort. And she also did remind us to be keen with our passwords, not to share these, not to make them so obvious. Some people have their birth dates or their daughter's name as passwords. So you need to tweak those to make sure that the password becomes a little more complicated for the hackers out there. She, of course, also highlighted the controls that are in place to prevent fraud, the maker-checker processes, of course, passwords, and the like. We also had our third speaker for the day, who talked about Islamic banking. Now, Islamic banking is a new way of banking that has come to our financial sector, and he highlighted some of the principles for Islamic banking. I recall that some of those are that Islamic banking does not encourage interest, rather it is profit sharing. It prohibits speculation. It also prohibits things that are haram. If you're to finance, you shouldn't be financing alcohol, you shouldn't be financing businesses that do pork and things that are prohibited by the Islamic faith. The fourth speaker, who was the last speaker for the day, talked about the key tax considerations in the financial institution sector, and they did highlight a couple of them. If you recall, They talked about the withholding tax regime, the deferred interest concept, and the debate that is happening between URA and the financial institution. She also did mention about the VAT regime for the banks and a lot of transfer pricing practices. Today we are going for the deep dive. Today's program is going to be digging deep into these topics to analyze the extent of how they impact the financial sector, the legal aspects that are at play, and how we as the banking law sector, or rather the banking law cluster, can feature in these sort of discussions. And I'm delighted to have our first speaker in the house, Mr. Senkumba Ahmed, who is the head legal at Bank of Baroda. Mr. Senkumba is going to be talking about Islamic banking in depth. He's going to give us not just an overview, but also give us the challenges, the legal aspects of the Islamic banking mode of banking, and a couple of more other details that were never discussed yesterday. Just to let you know that Mr. Senkumba Ahmed has had this as his master's thesis, so we're going to be keen to learn what he has been up to with his research in this area. Now, without wasting any further time, I would like to welcome Mr. Ahmed Senkumba to start us off with a deep dive in the Islamic banking. Thank you.
Okay, good morning, members of the legal profession, and let me hope that every person is fine. I'm going to be discussing about Islamic banking in depth. Yesterday's presentation by my colleague was in respect to Islamic banking and the tax aspects. So I will actually be taking you through making a general overview about Islamic banking. We shall actually start with the definition on Islamic banking, and thereafter we shall consider the modern trends, modern Islamic banking trends worldwide. We shall also consider the various modes of Islamic banking, the role of the Sharia Advisory Board in Islamic banking, accounts in Islamic banking, the common misconceptions about Islamic banking, the differences between convention and Islamic banking, and finally, how the Financial Institutions Amendment Act addressed Islamic banking. Now, when we talk about Islamic banking as a system of banking, we are saying that this is a banking system that is consistent with the principles of Islamic law. Islamic law known as Sharia, and its practical application through the development of Islamic economic system known as Fiqh al-Mu'amalat. Now, you come to realize that as a result of the amendment of the Financial Institutions Act, this particular phrase, Sharia, it is actually dominant, more so within that particular act. And when we talk about Sharia, we are referring to divine guidance as enshrined in the Holy Quran and the teachings of the Holy Prophet Muhammad, peace be upon him. So that is where we get the sources of Sharia. When we talk about Islamic banking as a system, it is majorly based on two major financial principles. The first is the prohibition of interest. So, Islamic banking prohibits interest in whatever form. Receiving and giving interest, it is actually prohibited. The second concept is profit and loss sharing. So after prohibiting interest, then the system adopts profit and loss sharing. Those are the two major principles underlying Islamic banking. or Islamic finance generally. And we are saying that the crux of Islamic banking, it is the freedom from riba, which is equated to interest. Because we are saying that interest or riba, it is prohibited in all forms of life. And the prohibition of this interest originates from the Holy Quran and the teachings of the noble Prophet Muhammad, peace be upon him. And all Islamic schools of thought agree on the prohibition of interest in Islam. So the scholars are unanimous about the prohibition of interest in Islam. Now, Islamic banking as a system, the modern practice, how it is being operated in various countries worldwide, it actually started in 1963 in Egypt. And by 1974, several banks had been established operating Islamic banking products and services. There was the Dubai Islamic Bank in 1975, the Faisal Islamic Bank of Sudan in 1977, the Faisal Islamic Egyptian Bank and Islamic Bank of Jordan in 1978, the Islamic Bank of Bahrain in 1979, and Bank Islam Malaysia in 1983. Now you come to realize that those are majorly Muslim countries. But we are also saying that America and Western Europe hasn't been exception to this particular trend. Over the years, Islamic banks have been established in America, Canada, United Kingdom, France, Germany, and majority of these Western countries. And Africa, it has also embarked on this particular board, establishing Islamic banking. Islamic banking in Africa, it's already being practiced in our neighboring Kenya, also Tanzania, South Africa, Senegal, Nigeria, among other African countries. Now, when we consider the Islamic banking in Uganda, you come to realize that in 2008, we had the OIC conference. And the OIC Business Forum in Kampala, among the results, was the establishment of the first Islamic bank in Uganda. The cabinet adopted the proposal, and in 2016, we had the Financial Institutions Amendment Act that was passed and assented to by the President on the 19th of January 2016. Among others was for establishment of Islamic banking as an alternative form of banking. Important to note in that particular act of 2016 that amended the Financial Institutions Act, it required a Central Sharia Advisory Council in Bank of Uganda to advise the central bank on matters of regulations and supervision of Islamic banking system in Uganda, and to approve products to be offered by financial institutions conducting Islamic banking. However, subsequently, we had the Financial Institutions Amendment Act of 2023 this particular year. And that particular Amendment Act just repealed the requirement of the Central Sharia Advisory Council in the Bank of Uganda. That was the gist. It was just to remove the requirement of having a Central Sharia Advisory Board. We shall actually discuss more about this Sharia Advisory Board at the bank level. Now, when Islamic banking starts here in Uganda, it will actually operate under two categories, either as an Islamic window or fully-fledged Islamic financial institution. When you talk about Islamic window, this is a part of a conventional bank, like Bank of Baroda, Stanbic, Centenary, as the case may be, that operates Islamic banking products and services. It is just a section of a conventional bank that operates Islamic banking products and services. And when we talk about a full-fledged financial institution, the implication is that the entire products and services of that particular bank comply with Sharia principles. And on the 8th day of September 2023, Bank of Uganda issued the first Islamic bank license to Salam Bank Limited as a full-fledged Islamic bank. Now, we consider the modes of financing and Islamic banking. In order to understand Islamic banking as a system of banking, we have to appreciate some of the modes of financing and Islamic banking. Now, people who are not conversant with this particular system sometimes believe that abolishing interest from these banks will just make them charitable rather than commercial, which is actually a total assumption, wrong assumption. You come to realize that some people have a belief that when you talk about Islamic banking, it's a situation whereof someone will just go to the bank and get a loan of 100 million and thereafter pay 100 million, of which we are saying that that is not the case when you talk about Islamic banking. You remember, we started with the pertinent principles about Islamic banking, that it is based on profit and loss sharing after prohibiting interest. Therefore, one of the ways to understand Islamic banking is to gain an understanding of the various modes of financing and products that are acceptable in Islamic banking. If financing is meant for commercial purposes, it can actually be structured on the concept of profit and loss sharing, for which case we are having the Musharak, which is actually a joint venture, and Mudarrab, profit sharing, have been designed since the very inception of Islamic commercial law. Now, these are partnerships. In case you want services for commercial dealings, then you can either consider Musharak, which is a joint venture, or Mudarrab, which is profit sharing. However, we are also saying that there are certain sectors where financing based on Musharak and Mudarrab, it's not practical. For such aspects, the contemporary scholars of Sharia have advised other alternative modes of financing, including Murabbah, which is cost plus, it's a sale. There is Ijara, which is leasing. There is Salam, which is forward sale, or Istisna, manufacturing contract, which we are actually discussing in details. So, first and foremost, we are considering Musharak as a form of financing under Islamic banking, which is a joint venture. When we talk about Musharak, it is an Arabic word which literally means sharing. And in the context of business and trade, it is a joint enterprise where all partners share the profits or losses of a joint venture. It is actually established through consent of all the parties without any duress, fraud, misrepresentation, as the case may be. Now, when we talk about Musharak as a form of financing, the parties, the customer, and the bank agree about the mode of distributing profits, and the profits are distributed according to a given ratio, percentage ratio, either 30 to 70, 20 to 80, 50 to 50, as per the agreement of the parties. However, it is not allowed to fix a certain lump sum figure that you actually be paid 100 million or 50 million or 20 million, as the case may be, simply because we are talking about sharing of profits and losses. A situation whereby there is a loss, there is no way how you can compel someone to pay that particular lump sum figure. And the loss will actually be borne proportionate to the investment of capital. what we are trying to say here is that in Islamic banking, the parties can agree about the mode of sharing profits. However, in case the venture has suffered a loss, the loss is as per the capital contributed by each party. It is actually that particular principle in the famous maxim that profit is based on the agreement of parties, but loss is also subject to ratio of investment. The share of capital contributed can either be in cash or in form of commodities. And in case it's in form of commodities, then the value of the commodities shall determine the share of the partner in that particular capital. Every partner has a right to take part in management of the business and work for it. However, in certain circumstances, the management can actually be left to one person, and it will also impact how the profits are being shared. You come to realize that there are circumstances whereof the bank may actually not be interested in becoming being a perpetual partner in this particular venture, for which the contemporary Sharia scholars adopted the system of diminishing musharak. The share of the financiers, the share of the bank in this particular aspect will actually be divided into the share different categories, whereof the customer will periodically purchase the shares of the bank, increasing the customer's share, whereas decreasing the shares of the financier of the bank, up to the extent whereof the bank has no any share in that particular regard, and the customer becomes the complete owner of that particular enterprise, as the case may be. So when we talk about musharak as a form of financing, we are just considering a situation whereof the bank and a customer contributes capital for investing in a given venture. As we shall see when we are actually concluding, Islamic banks engage in trade, industry, agriculture, investing in immovable properties, as the case may be. So here we are actually majorly talking about commercial transactions. We are majorly talking about banks being engaged in business, commercial enterprises, as the case may be. The second concept, the second mode, it is actually mudarraba, profit sharing. Under this particular mode, it's a special kind of partnership where one partner gives money to another for investing in a commercial enterprise. The investment comes from the first party, who is called the Rabul Mal, the person who gives the capital, while the management and work, it is exclusive responsibility of the other person, who is called the Mudarrib. So here we are having someone who is investing money, and we are also having the manager. Like Musharak, the parties agree how they will actually share the profits in a given ratio, either in 40 to 60, as the case may be, depending on the agreement. So the assumption is, in case you are entering into these transactions, you must actually be keen about the negotiating the various percentages of profits. Likewise, we are also saying that the parties cannot allocate a given sum, that I will actually be getting 30 million on a monthly basis, half yearly, annual basis, as the case may be. As that will actually be, that will amount to riba, which is prohibited in Islamic banking. And here, in case there is any loss, the loss, it is only suffered by one person, who is called the Rabul Mal, the person who has invested capital, simply because the opposite party, the Mudarrib, who is the manager, does not invest anything. Maybe his loss is just restricted to his labor in that he has actually tirelessly worked for this particular venture, but it hasn't provided fruits. However, it is based on the condition that this particular manager has worked with honesty and diligence, failure of which, in case there is any negligence or dishonesty, will actually be liable. So when we talk about Mudarib as a form of financing, here the bank gives money to someone to invest in a commercial venture. You just maybe consider a certain business. For instance, in a certain area, there is feasibility study has been conducted, and it is actually found out that the business of an arcade to be constructed can actually yield profits. In that particular aspect, the bank will provide money to a certain manager for purposes of constructing that particular arcade, and after the construction, then the arcade will actually be in position to generate profits, which will actually be shared according to a predetermined ratio between the bank and that particular manager, the customer. Then we are having Murabah. Murabah, it is actually cost plus. This is a pure sale. This is a kind of sale in that a seller agrees with the purchaser to provide a specific commodity on a certain profit added to his cost. So the basic ingredient is that the seller discloses the actual cost he has incurred in acquiring the commodity and then adds some profit thereon. This profit may be in lump sum or may be based on a percentage. Now, in Sharia, Sharia law prohibits someone to sell something for which has no ownership, either actual or constructive. And the product or the asset being traded must also be Sharia compliant. It shouldn't be haram. The subject of that particular property must be in the ownership of the owner, the person who is selling the same. Now, when we talk about Murabah as a mode of financing, you just consider a situation whereof someone wants to purchase a certain house. Maybe you've gone to a place like Chanja and you've spotted a certain house on sale. So that particular house, it may actually be valued worth 300 million. So you come to the bank and inform the bank that I want this particular house to be purchased on my behalf. So the bank will actually look through your proposal, and thereafter the bank will purchase that particular house in its own names. We are saying that it's a requirement under Sharia that you cannot sell something for which you have no ownership. Therefore, the bank has to first assume ownership of that particular house. And thereafter, it will actually be clear, there will actually be full disclosure that we have purchased this particular house at 300 million. Therefore, we intend to make a markup of 50 million. Whereof it will actually be clear that they have actually sold you that particular house at 350 million, while knowing that the bank has made a profit of 50 million. Now, under such circumstance, there is an asset being traded as opposed to the conventional system whereby it's just money, and the concept of sharing of profits and loss. In that, in case that particular house, maybe it is gutted by fire and it is destroyed, there is no way how the bank can again go to that particular customer to claim for the balance. The concept of sharing of profits and losses, the bank will also suffer the loss in that particular regard. That's how Murabah transactions operate. Then we are having Ijara, which is leasing. Ijara means to give something on rent. In In this particular context, we are saying that ijara is a transfer of rights of a particular property to another person in exchange of rent claimed from him. Now, this is actually similar to leasing. Ijara also has its rules, whereof the property being leased should actually be owned by the financier, in this particular aspect being a bank, and the right is passed on to the customer for use while paying rental dues. In that particular arrangement, after the expiry of the period of the lease, then the property reverts to the bank. And there are circumstances whereby that particular moment, the customer and the bank, after expiry of the lease period, they can agree to enter into a murabah transaction for sale, whereof the property will actually be valued and it is finally sold to the customer. So when we talk about ijara, it is actually leasing, whereof a certain property, you just consider a certain property like maybe a vehicle owned by the bank. It is actually leased to the customer for purposes of business, and the customer is actually paying monthly rental dues as per the agreement. We are having salam, which is forward sale, and istisna, which is manufacturing contract. It is a basic principle in Sharia that the commodity being sold or transacted must actually be variable. The seller must have physical or constructive possession of the commodity. However, when you consider this particular requirement, the commodity must be existing. The seller should have acquired the ownership of that particular commodity, and the property should have come in possession of the seller, either physically or constructive. And we are saying that there are exceptions to that particular general rule. That particular general rule is applicable also in murabaka transaction, pure sale. But when we talk about forward sale, salam, and istisna, manufacturing contract, it is actually the exception. That is the only window where we are having the exception to those Sharia principles. And these are also sales of a special nature, but there is no requirement of having physical or constructive ownership of the property. Now, in salam, this is where the seller undertakes to supply some special goods to the buyer at a future date in exchange of advanced price prepaid at spot. Here the price is cash, but the supply of purchased goods is deferred. Now, this is the situation. When you talk about Islamic banking, you come to realize that institutions will even venture into agriculture, whereof the bank will actually provide funds, will finance maybe cotton growing, sugarcane plantations, coffee plantations, as the case may be, by paying this particular farmer a lump sum amount. And this particular farmer will actually be requested to provide the harvests to the bank. So when you talk about Islamic banking, it's not just about banks dealing in money, but also venturing in trade, industry, agriculture, investing in immovable properties, as the case may be. To be effected in commodities, the quality and quantity of which can be specified. The date and place of delivery must be specified in the contract, and it cannot be effected in respect of things which must be delivered at spot in Sharia. For example, gold in exchange for silver. According to Sharia principles, in case you are exchanging gold for silver, it should actually be a spot transaction. Therefore, under such circumstance, we cannot invoke salam, the forward sale. This salam, you come to realize that it is actually applicable to a country like Uganda, which majorly has its backbone in agriculture, whereof these Islamic banks will finance agriculture and boosting the economy in that particular regard. Then we are having istisna, being the manufacturing contract. When we talk about istisna, it means to order a manufacturer to manufacture a specific commodity for the purchaser. It is the second kind of sale where the commodity is transacted before it comes into existence. The price should be fixed with the consent of the parties, and the specifications of the commodity intended to be manufactured is fully settled between them. Istisna can be used for providing the facility of financing in certain transactions, especially in housing finance sector. Now here, when you talk about istisna as a mode of financing, it's a situation whereof the bank contracts a certain company, construction company, maybe Vicon, in order to construct various apartments or residential houses at a price already fixed. Maybe they will be constructing those houses for an amount of 100 million. And after the bank pays the amount, and after the construction, the bank will actually be owning such houses. And in turn, the bank sells such houses to various potential interested parties at a markup while making a profit. The construction, the manufacture actually was within a range of 100 million, but subsequently the bank is in position to sell them on open market at maybe 120, 150, as the case may be, hence making a markup of that particular difference. When you talk about salam and istisna, it is necessary in salam that the price is paid in full in advance, while it is not a requirement in istisna manufacturing contract. The price can actually be paid in different phases. The subject of istisna, it's already a thing which needs manufacturing, while salam can be effected on anything, no matter whether it needs manufacturing or not. And the time of delivery is an essential part of the sale in salam, while it is not necessary in istisna, that the time is of delivery is fixed. And the contract of salam, once effected, cannot be cancelled unilaterally, while the contract of istisna can be cancelled before the manufacturer starts work. Now, having considered the various modes of financing, then it is also crucial and pertinent to consider what is being referred to as the Sharia Advisory Board in Islamic banking. And we are saying that one of the distinct features of modern day Islamic banking, it is the role of the Sharia Advisory Board, which forms an integral part of an Islamic bank. The Sharia Advisory Board is a key element of the structure of Islamic financial institution, carrying the responsibility of ensuring that all products and services offered by the financial institution are compliant with Sharia principles. Islamic banks and banking institutions that offer Islamic banking products and services are required to establish a Sharia Advisory Board in order to advise them about their dealings. So what we are trying to say is that for every bank that claims to be operating Sharia banking, either as a window or a fully-fledged financial institution, it must appoint and maintain Sharia Advisory Council. It is actually a board of experts in Sharia in order to ensure that the transactions of that particular bank are in conformity with Sharia. The board supervises the Sharia compliance of transactions in the bank. The Sharia advisors ensure that all transactions carried out are in strict compliance with the Islamic principles of banking. It also approves aspects in the Memorandum of Association, Articles of Association, and regulations, as well as forms, policies, and procedures used by the bank. Approves the standard agreements and contracts pertaining to the bank's financial transaction. They also give Sharia opinion regarding financial statements of the banks at the end of the financial year. The same way how the auditors, external auditors, express their opinion about the financial statements. Also, these Sharia advisors are expected to express their opinion about the financial statements to the effect that all the transactions have been conducted in conformity with Sharia principles. And it is this particular group which writes off prohibited profits earned through non-compliant ways to the provisions of Islamic principles and spent in charitable purposes. In case they realize that certain transactions were never transacted according to Sharia principles, they should not allow such profits to mingle with the other profits. Instead, they will just write off such amount, and it is maybe that amount which is actually spent in charitable purposes, like maybe giving it to the needy, the poor, institutions like Sunny Babies Home, among others. It also ensures that distribution of profits and bearing of losses are calculated according with Islamic principles of Sharia. They present an annual report in front of the General Assembly of the bank about the transactions in that particular year. So, essentially, when we talk about the Sharia board, it is majorly a board which is mandated for any institution operating Islamic banking to advise the same on the applicability of Sharia principles. Mind you, when we are starting, I informed you that the Financial Institutions Amendment Act of 2013 repealed the requirement that had been inserted in the Financial Institutions Amendment Act of 2016 that had required the central bank to have a Sharia Advisory Council. Therefore, according to our structure in Uganda, we shall be having Islamic banks having Sharia Advisory Board at respective bank level without the requirement of having a similar board at the central bank. That was actually the essence of the amendment. Then, we consider the accounts in Islamic banking. And we are saying that when we talk about Islamic banking, it is actually a form of banking. It isn't something which will actually be completely different from the general system of banking. However, the essence is to ensure that this particular banking complies with Islamic principles. And we are saying that we are having two major accounts in Islamic banking. We are having accounts, deposits not committed to investment, which take the form of current accounts and saving accounts. And we are also having deposits committed to investment, which are called investment accounts in Islamic banking. Now, when we talk about accounts, current accounts in Islamic banking will actually be operated in the same way how conventional banks operate such accounts, whereof a certain company or entity opens up an account, it is actually given checkbooks, it can withdraw, it can deposit, as the case may be. Then, when we talk about saving account, yes, someone can just keep money on a saving account. And we are saying that the bank has a degree of convenience in the use of such amount deposited with it. In that, it is majorly that amount which is actually employed in various commercial ventures. In that, in case that amount, a certain customer has kept money on a certain savings account, the bank, at its own discretion, can provide what is called in Islamic banking hiba. Hiba being a gift. that you kept your money with us for this particular duration, which money we have utilized. Therefore, we are giving you this particular gift. Now, that is not interest, simply because it is not a guaranteed return on the money. However, it is just a gesture being given by the Islamic bank to this particular customer. Then, investment accounts in Islamic banking, and I think this is the peculiar account which distinguishes Islamic bank from conventional bank. When we talk about investment accounts in Islamic banking, Islamic banks offer profit and loss sharing investment accounts, usually based on mudaraba partnership contracts between the bank and the customer. Now, this is a situation whereof the customer has deposited money with the Islamic bank on an Islamic investment account. And it is actually very clear that this particular person wants to do business with the bank. Therefore, you just deposit money on the investment account so that the money can actually be invested. When you talk about the various modes of financing, the cost plus, the mudarrab, the musharraka, among others, the money actually comes from here, whereof the bank has employed the funds from this particular account, and it has actually been given to various customers for investing in various commercial ventures. Again, here, you also agree about the mode of sharing profits, either 50-50, 60-40, 70-30, as the case may be. Again, in case there is any loss as a result of investing that amount, the loss will also be borne between the bank and the customer. However, statistics has always revealed that banks hardly declare such losses, simply because we are having the concept of takaful, which is Islamic insurance, whereof the banks will even insure such accounts with insurance companies involved in Islamic finance, in that they absorb the shock of any likely loss. In this particular arrangement, we are having the restricted investment account and the unrestricted investment account. When we talk about restricted investment account, it's a situation whereof the customer informs the bank that I want my money to be invested in agriculture, that was restricted, or to be invested in trade, or to be invested in real estate. When we talk about unrestricted investment account, under such circumstance, you are just giving the bank the liberty to invest the money wherever the bank realizes that there is good business. Now, that being the case, as we are about to wind up, we consider some of the common misconceptions about Islamic banking. Common misconceptions about Islamic banking. Now, with the growing impact and influence of Islamic banking, it is necessary to clear up misconceptions and myths that may be the source of misunderstanding about the industry, Islamic banking. In my preamble, I actually informed you that in Uganda, the process to establish Islamic banking started way back in 2008. And the cabinet had to study the system, the economists from the Ministry of Finance, the members of parliament had to consider the system, among others. However, some of the issues why the system had delayed, and also why it hasn't been developed in certain jurisdictions, it's because of the myth and misconceptions associated with this particular system. And the first one, there is that particular misconception that the system finances terrorism. This is actually the far common misconception and an excuse to disregard Islamic banking as a legitimate discipline. Let it actually be noted on record that Islam condemns terrorism in whatever form. The illegal use of violence, it is actually condemned in Islam. In Uganda, we are having various laws and regulations pertaining to terrorism and money laundering and financing of terrorism. In that, in case banks have been established, like Salam Bank, it is also bound to be guided by the same requirements. It has to comply with the same requirements. So this will actually can never be an argument in order to delay this particular system in any jurisdiction. The second, that it is for Muslims only and aimed towards Islam's domination. Now, in our preamble, we have looked at the global trends of Islamic banking, whereof the system is more developed in UK, America, and other Western countries. These are not countries under Islamic jurisdiction. So it is just an alternative system of banking, but just being guided by Sharia principles. I got an opportunity of interacting with certain officials from Salam Bank, and I came to realize that majority of the top officials, they are actually not Muslims, and they are willing and receptive to this particular system, and they want to promote the same. When I was actually doing my master's thesis at Makerere in this particular system, when I ventured into the legal hurdles, the implementation of Islamic banking in Uganda, I actually interviewed various officials from the central bank. As by then, there was Mr. Ndiareba Grace, who was the director of commercial banking. As by then, there was Titus Mulindwa, the deputy legal counsel, among others. I never interacted with any Muslim, but they were actually knowledgeable in this particular area. Another aspect, which is a misconception, that it only provides interest-free loans. We are saying that Islamic banks do not provide interest-free loans. Interest-free loans are just meant for cooperatives and also charitable institutions. In case it's an issue of commerce, we must actually open up to the principle of sharing of profits and losses. Another aspect, that it is automatically immune from unethical practices. There is that particular misconception that the fact that this is Islamic banking, there will not be any fraud like how it is in other banks, simply because the system is incorruptible and it cannot be at fault. No, that's a misconception. When we talk about Islamic banking, the same problems which may actually be associated with conventional banking, like hacking, like over-debiting of customers' accounts, the same problems are also likely to happen with such banks. Another aspect, another misconception, that it is just an Islamic copy of the conventional banking. That there is a misconception that Islamic banks actually give depositors interest in the name of profit. Now, when we are talking about factors of production and also commercial aspects, economic aspects, the return on capital, the return on investment, among others, there is always a distinction between interest and profit. In case someone confuses interest and profit, then we will actually be making this particular argument that I haven't seen the difference between Islamic banking, because that particular markup, it is also the interest. Here, we are talking about asset-backed, whereof there is an asset being traded, as opposed to money being exchanged for money in order to make that particular interest. So, under such circumstance, we must actually distinguish between interest and profit for purposes of understanding this particular system. Then, differences between conventional and Islamic banking. Islamic banking and conventional system, as it's being practiced here, has some differences. In the conventional system, money is a commodity, besides being a medium of exchange and store of value. Therefore, it can be sold at price higher than its value, and it can also be rented out. However, in Islamic banking, money is not a commodity, though it is used as a medium of exchange and store of value. Therefore, it cannot be sold at a price higher than its face value or rented out. Now, this is where the major distinction lies, that in a conventional system, money can actually be transacted. In Islamic banking, money cannot be transacted, because in case you transact in money, you end up coming up with interest, which is prohibited. The second is about time value is the basis for charging interest on capital. In our conventional banks, we always consider the time value for money and the interest attached. In Islamic banking, profit on trade of goods and services, it is actually the basis of charging profits. The system is based on profit sharing. So profit on trade of profit on goods or charging of services, it is actually the basis of earning interest. Then interest is charged in conventional banking. Interest is charged even though the organization suffers loss by using the bank's funds. Therefore, it is not based on profit and loss sharing. In Islamic banking, operates on the principles of profit and loss sharing. In case the businessman has suffered losses, the bank will share these losses based on the mode of finance used, either mudarrab or musharak. You come to realize that in Uganda we are having problems whereof the traders have got loans from banks and they have suffered calamities, either arising from business being gutted by fire, and yet they were financing loans among others. In conventional banking, those loans must be paid. In Islamic banking, such an amount, we do not expect the Islamic bank to insist, simply because it was also a partner in that particular business. Therefore, it has also suffered. In conventional banking, the governance structure is majorly based on the board of directors. In Islamic banking, besides the board of directors, we are having an extra layer, being the Sharia Advisory Board, which plays a vital role in ensuring that the products and the services of the Islamic bank are in conformity with Sharia. Finally, just in some few minutes, we consider how the Financial Institutions Amendment Act of 2016 and the 2023 addresses Islamic banking. We also consider the Financial Institutions Islamic Bank regulations of 2018 as passed by the central bank. First and foremost, within the amendment of 2016, there is recognition of Islamic banking among the various classes. For the first time, the amendment recognized the Islamic bank among the various classes which can actually be applied for purposes of transacting banking business. That is actually class 10 of the Financial Institutions Amendment Act. The second, within that particular Amendment Act, is the Islamic window by the existing banks. We stated that when we talk about Islamic window, this is a section of Islamic bank of the conventional system, a bank like Baroda, but having a section that operates Islamic banking products and services. So that particular window, it was captured within the Financial Institutions Amendment Act of 2016. Then we are having the Sharia Advisory Board. The Amendment Act requires every financial institution which conducts Islamic financial business to appoint and maintain Sharia Advisory Board. It is actually a dictate within that particular act. Then The amendment exempted exemption from prohibition and restriction under section 37 and 38. You come to realize that the major reason why Uganda we hadn't started Islamic banking, majorly it was because the Financial Institutions Act prohibit banks from engaging in trade, industry, agriculture, and investing in immovable property under the provisions of section 37 and 38 of the Financial Institutions Act. However, with the passing of the Financial Institutions Amendment Act of 2016, exempted financial institutions that will be offering Islamic banking products and services from this particular requirement. Therefore, banks that offer Islamic banking products and services are exempted from this particular requirement simply because their major business it is in respect to trade, commerce, industry, agriculture, and investing in immovable property. That's actually the end of my session. Thank you very much for listening to me. Mr. Moderator, I hand over the mic back to you.
Thank you very much, Ahmed Senkumba. That has been a presentation from Ahmed on aspects of Islamic banking, not only in Uganda, but also the concept in general. I did mention to you that today was going to be a deep dive, and I'm excited for our audience out there. I'm sure that your interest has been piqued in this new Islamic banking phenomenon, and I'm hoping that this time round we're going to have a stream of questions coming through for our speaker on Islamic banking. I do want to remind you that there's a Q&A tab on your screens. If you have a question, just please deposit that question in that Q&A tab. We will pick it up and the speakers are going to attend to it in the Q&A slot. Now, I do recognize that we have considerable attendance today, and thank you for having stuck with us from yesterday. I know that there's people like Mr. William Biaruhanga, who also attended yesterday's session and is also here. I've seen a couple of my classmates, Sarah Uamahoro, I see Tracy Kakonji, but I also see other notable attendees. I see Madame Gertrude Wamala, Brian Shonobi, I also see you. Thank you guys for keeping with us until today. So we are now going to go into our second speaker. And our second speaker is also going to be providing a deep dive in ESG integration in the banking system, and especially navigating the legal implications for sustainable lending and borrowing practices. Remember, most financial institutions have now adopted ESG as their key goal among those top goals for any institution. ESG, I think the speaker coming on is going to explain further, is the environmental and social governance considerations for any financial institution to adopt. And this and more we will be hearing from Mr. Innocent Damurira. Mr. Innocent Damurira is a partner at DIT Advocates who has extensive knowledge about corporate governance and ESG aspects. So do make welcome to Mr. Damurira to run us through this topic as we head for our Q&A session.
Thank you, moderator, for having me. I'm excited to be speaking about this subject. We have prepared slides, and we will have a good time running through and sharing the experiences here and there, and what we really think the banks should be attending to as they look at the bigger picture. Colleagues, I will be taking you through a shared topic on ESG integration in banking, looking at navigating legal implications for sustainable lending and borrowing practices. And I will be drawing examples from different jurisdictions, but I will have good emphasis for Uganda. I will be looking at this outline. I'll look at the ESG as a concept so that a colleague out there who has not interacted with this subject will be able to appreciate what we will be discussing today. I will do a breakdown of ESG in the different layers as it should be. I also look at ESG across developed jurisdictions. You realize that many concepts and practices may not start here. They may start from somewhere, but what is good we adopt, we adapt. I also look at the ESG regulatory framework in Uganda. And then I also look at approaches to integrating sustainability in banking. Then I look at the risk-based vis-a-vis value-based lending. And then we will have a conversation. Now, what is ESG? This concept is not new. It has been around for some time. What perhaps could be changing now is how we treat it in respect to our entities, our corporations, the businesses we are running, and then in this particular case, the banking sector. ESG looks at the environment and social and governance, and we are happy to break it down and start the environment. Someone out there watching and following this symposium would be wondering what should be considered under the environment. We have considered that these are only examples. Look at the carbon footprint of an organization or an entity. ESG environment looks at how an organization deals with its waste management. Ladies and gentlemen, you know that organizations produce waste, and the requirement is that they dispose of that waste in a manner that is acceptable, in a manner that does not interfere with the integrity of the environment. So we believe that an organization or a bank or a corporate entity, even individuals, should be interested in how the organization they deal with or they interact with deal with their waste. Then we look at climate change. Ladies and gentlemen, we do know that it is not possible for us to be sustainable, or for any entity to be sustainable, if we don't care about our environment. I will tell you that you could have a very good progressing company somewhere seated in Nakasero, but when the entire Kampala floods upon the rain, you won't be able to reach home. So it is not possible to only build the strength of your company. It is also important that you care about the environment, and that way you'll achieve the bigger picture of sustainability. Then we look at energy consumption. So we believe that there are many other examples that you can pick from other areas, but these are only examples that we have thought we should pick to explain the aspect of environment within the ESG bigger concept. Then, ladies and gentlemen, we are happy to say we will look at social. The social aspect of ESG, we look at the responsibility of the company, in this case, the responsibility of a bank or a corporate entity. Its corporate social responsibility is important. It is not enough that the organization is making a profit. It is important that they do something beyond the profit that they are making. It looks at safety. Colleagues, there are organizations that you may be advising where a lapse in safety will lead to a fatality. Take the example of a utility organization like, say, Umeme. If someone in charge of safety at Umeme failed to observe the requirements of PPE, and someone say does not wear the required glove, and they go up the pole, that person may die. that is a fatality arising from failure of safety. So as we deal with these organizations, it is very important to look at the social, then the diversity, then the health, and then the community impact. What is the organization we are dealing with or we are advising doing in its community? It is not enough to operate, to do what is by the book in your strategy. It is important to look at the community. What is the community suffering? And then be able to do something under social. Then we got governance. Ladies and gentlemen, this area is very dear to me. I have had a stint managing compliance and governance of a big IT organization, and I do know that a failure of governance will lead to a failure of an organization in the long run. So I really believe that if an organization does not take care of its governance strategy or draw a proper governance strategy, it may not be possible that that organization will survive in the long run. So it is important that an organization is accountable. Now, still, we will look at the rights. We will look at the transparency. How is the organization transparent? I will tell you that the governance structure of an organization will depend on the nature of organization, the nature of organization. Now, for example, if an organization is a listed organization, take for example a bank that is listed on the Uganda Securities Exchange, there are disclosure requirements that are required under the listing rules for that organization that is listed. And those disclosure requirements will fall in right into its governance requirements. And why are the disclosure requirements very important? That shareholder, that client, that other investor that may choose to be part of that organization by purchasing shares on the stock exchange needs to know exactly what is happening in that organization. So if you suspect that something dangerous or something that will threaten the continuity of the organization is likely to happen, the requirement of disclosure is that you disclose that within a period that is provided under the listing rules. So depending on the organization, colleagues, you are advising a bank, you're advising a listed entity, it is very important that you look at the governance requirements as they relate to that entity that you are advising. Now, I thought it would be important, colleagues, to look at ESG across other jurisdictions. How are other jurisdictions implementing and looking at the ESG regime? Now, in the UK, for example, prior to 1st January 2022, ESG decision-making drivers for financial institutions in that place looked largely at enterprise risk environment, what are the risks associated. It looked at strategic business goals. Every business has a strategic business goal. It has a strategic business plan if it is to run well. So those organizations would make decisions depending on their strategic business goal. What are the objectives of the organizations? What are the financial resources that are available and that are interplay in terms of doing what they are supposed to do? And what are the goals of that organization? Now, that prior to 1st January 2022, there came the FCA policy statements on climate change. Now, that policy statement requires that while the other strategic business goals, enterprise, and so many other factors that an organization may consider while making its decision, it must also, the policy requires that it must also issue statements relating to how it is dealing with the environment, how it is dealing with the climate. So it's not enough to make a decision based on what your business goal is, but you must be able to show what you are doing with the environment. I know that colleagues may be aware of this case, the Client Earth versus Directors of Shell PLC in the UK that was filed. And it is very important because it lays a perspective on how far the people out there, the clients that we serve, the organizations are now looking seriously at this ESG regime. Now, the facts of this case that are relevant are that this is the first climate derivative action against the board of directors under the UK Companies Act, and that targeted corporate directors personally for the company's energy transition strategy. And this was filed in Feb 2003. Now, whereas this was not successful, what I find very important to pick away is that the ESG compensation is unstable. This is a shareholder that is seeking to ensure that the directors are implementing a climate related strategy. Now, I'll tell you that it is difficult to take this. A derivative suit, the bar is still very high. But even when the bar is very high, you see that the shareholders are very careful. They want the sustainability. They want to ensure that organizations do what is right, and that is what will deliver the bigger picture. Other jurisdiction, look at South Africa. Currently, you will look at a PwC report, and PwC is saying in its last report that we are at a turning point. Financial factors are no longer viewed as the preeminent drivers of value and sustainability, and has become strategic. The board and CEO level sustainability has become a CEO and board level issue. To succeed, business has to respond to important issues facing the world today. Companies need to demonstrate how they create value for shareholders and for society through insightful, balanced, and trusted performance and disclosure. Ladies and gentlemen, it is no longer enough that CEOs and the boards look at just the business as it is. It is important that they look at an insightful and balanced, trusted performance disclosure. Global. IFRS International Sustainability Standards Board announced that the International Financial Reporting Standards Foundation, IFRS, new global sustainability and climate disclosure standards will be effective as of January 2024. Climate, key area is climate disclosure standards. Initially, IFRS was looking at the books, looking at the integrity of the books. Right now, the books are not complete if there are no global sustainability and climate disclosure standards, if they're not followed. So you must, as an organization or as you advise an organization, ensure that they should be able to say something about what are they doing in their environment, what are they doing in their social areas, what are they doing for governance. And one may ask, do we have a single law in Uganda coming back here? A single law or regulation that deals with ESG? My answer would be say no. But there are several laws and regulations that look at this area, and where we are able to pick some of those guiding factors and principles. Let's start with the 1995 Constitution as it relates to the environment. Look at the National Environment Act, which was actually amended, and I am aware that the NEMA people are doing some enforcements to save the environment. Look at the Employment Act and in respect to how it is protecting the employee. Look at the amendments, not even listed here, NSSF, trying to protect every employee, irrespective of doing away with the requirements of the numbers. At the workplace, every employee should be able to save something. That is the area of social. Then look at the Occupational Safety and Health Act of 2006. There are several other laws. You will not find one law that will guide the organization you advise in the areas of social, environment and governance, not at all. But you'll pick from the different organizations, the different laws and regulations. Now look at the second box dealing with governance. The Companies Act offers several requirements in terms of governance. Look at the Capital Markets Authority. Look at the listing rules, especially if you are advising an organization that is listed on the stock exchange. And there are organizations here, colleagues, that are listed on both the Uganda Securities Exchange, but also listed on the Nairobi Securities Exchange. Now, that would mean that the compliance and governance requirements for such an organization will be wider, because you will be required to observe the rules as they relate to, say, disclosures in Uganda, in USE, and you also be required to observe the requirements of NSE listing rules. And from my experience, I have found the NC listing rules quite stringent. But if you are advising an organization that is listed on both, you'll be required to look at both indeed. Now, approaches to integrating sustainability into lending. I have looked at, created two credit risk scorecards that are imaginary for a bank or for a financial institution that is looking at lending. The first scorecard is looking at value-based lending, and the second one is looking at risk-based lending. I will start speaking to the risk-based scorecard. Now, every financial institution, before they do an investment or give out money in form of, say, loan or in form of financing, the organization will do an assessment, a credit risk scorecard. And if a borrower does not pass that scorecard, the person at the bank in charge of that lending will have to make a lot of consultations before they give that or deal with that financing. Now, this is an imaginary scorecard that the banking officer will engage while engaging with someone who has come to borrow. They will look at the borrower's financial cash flow. Of course, if it is an organization, it is looking for financing, it is very important that they have sufficient cash flow to pay back the loan. So I want to feel that looking at the financial cash flow will be very important before deciding going to that investment on the part of the bank. If an employee is seeking for an employment, a salary loan, they'll look at the employment history. The bank might consider dealing with an employee who has some level of stability at their places of work. If you, in the space of 5 years, you've worked for 5 employers, you might be considered someone who is not stable, so you might not receive a salary loan. So someone who is looking at an officer will be able to look at your history. Then the credit history, look at the credit reference bureau. Currently, every borrower has a credit reference card. They look at, are you borrowing from one bank and then you do not pay and then you run to another bank? The bank will be interested in that. They also look at your business debt to income ratio. You may have, many times, organizations borrow when they still have some debt, but they look at your debt and then the income that the organization is making. They look at books of accounts, SME loans. They look at regulatory considerations. There are rules that are regulatory, and before the borrowing happens or the lending, the organization is required, the bank is required to look at those considerations. And then they look at the nature of business. Now, that is a scorecard that is imaginary for a risk-based lending. This bank A is ensuring that the money that is borrowed will be brought back. They do not want a non-performing portfolio. Now, bank B on my left is value-based lending. Now, when a bank or an organization is going to invest and they are value-based lending, they will start with an ESG variable. Before they make a decision on whether to engage into financing, into lending, they will be interested in how, in the ESG metrics of that organization that the bank is going to deal with. Are you an organization that is disposing your waste in the environment? The bank that is careful about ESG will be interested in how you dispose your waste. Are you engaged into modern day slavery? The bank that is interested in ESG variables will be interested. Now, that on addition to all the other parameters that the other scorecard B will have. But the difference here is that in addition to the other requirements, the other scorecard areas, it will also include ESG variables. Ladies and gentlemen, the conversation around ESG is a big conversation. Which approach to investing screening is being adopted by Ugandan banks? Negative or positive screening? Ladies and gentlemen, negative screening happens in a situation where a bank or an investor chooses to refrain from investing in an entity because of its low metric on ESG. Let me just repeat. As an organization choosing to invest, you choose to refrain from investing in an entity because of its failure to observe ESG requirements. And then, on the other hand, positive screening is where you choose to invest in an organization because of its level of observance of ESG requirements. My question to you is, that bank you are advising, that entity you are advising as a lawyer, does it have negative or positive screening on its scorecard? Does it even look at this in terms of ESG? Does it even bother to know how that organization they are lending to disposes its waste, whether it cares about the environment where it is operating? Do our banks have a loan portfolio dedicated to ESG enhancement? Ladies and gentlemen, a loan portfolio dedicated to ESG enhancement, I would explain it this way. Every bank wants to perform well on its loan portfolio. But it will have several people who will not be able to access or pass the criteria of getting that loan from the bank. What do the banks do about those people? What do they do? I will tell you that I've had some banks dedicating some particular amount of money specifically to those borrowers that are observing certain aspects in the environment. I've had banks as well getting out of the bank and in their corporate social responsibility, they do go out and plant trees. I've watched one of the banks posting of planting and growing more than 1 million trees. That's amazing. When an organization you are advising chooses to take that direction of taking care of the environment, that organization looks very endearing because it looks like, in addition to looking out for that profit, it is caring about the environment where it is making the profit from. What are the banks doing for the population that does not pass the credit risk score? Do they leave them to resort to unlicensed lenders? I have looked at books of accounts of banks. Does any bank give any statistics on the number of customers that are sent away that do not pass the scorecard and therefore not given loans? Do we have those statistics? When a bank sends away a client that has that came to ask for a loan or financing, where does that client go? For a bank that is looking at ESG as a factor that defines its strategy, it is very important that it knows where that person who came for the loan and did not pass, where did that person go? In the UK, because of the need because of the nature of UK, there are many people who earn weekly and monthly. Many people earn weekly. There are lenders who are referred to as payday lenders. Now, initially, these payday lenders were not regulated. Today, even the payday lenders are regulated. People who give money to others to go through, just to run through the month, and they will be paid at the end of the month. They are regulated. They are regulated because it is not sustainability if someone comes to the bank to get financing and that person does not pass the criteria, and that person is sent away, and somewhere out there, someone charges 10% interest per day. Ladies and gentlemen, I know that there are financials out there who are charging an interest that is so high up there that there is no business person who can surpass it, who can survive failure if you borrow at that rate of interest. So I feel that the banks should be, if they incorporated the ESG within their practices, they should be interested in the batch of people who come to the bank and never pass that criteria. The loan agreements have a clause on sustainability of the environment. You may have an answer or you may not. I don't think so. Would a bank recall a loan for lenders' deviation from agreed sustainability principles? Ladies and gentlemen, I wonder if a bank has advanced a loan to a company and that company is clearly not observing the requirements of the environment, would the bank be interested in recalling that loan? My thoughts are it is very important that the bank is interested in what the borrower is doing with the money, in ensuring that it does not do contrary to the ESG requirements. And the last thought is, would incorporation of ESG lead to higher returns on equity, lower risk, and lower cost of capital for companies with better ESG metrics? I was thinking of the energy sector just as an example. I had an opportunity to work for many years in the energy sector, and I can draw an example from the energy sector. One time, one of the members of the SMT was asked why the current utility, the hold of the license of the concession, negotiated a quite higher rate of return, which is 20%. And the question was, within the ESG environment, the answer from that ESMD of that utility said, we negotiated a very high rate of return when we entered into this market in 2005, because the energy sector was extremely unattractive. Unattractive in this sense, the network was very bad. So there was no one who would be interested in lending or investing for purposes of investing that money in the energy sector. So the only way that we would come in and invest, we had to negotiate a high rate of return. Now, ladies and gentlemen, normally when an investment is attractive, when ESG requirements are observed, there is normally a likelihood that that entity will be able to access cheaper capital. Because right now, after close to 20 years of rehabilitating that sector, the sector is attractive. Now there will be several other investors who are willing to invest in the energy sector. So in a nutshell and in a broad sense, it is true that when organizations observe ESG requirements, there is a likelihood that there will be higher returns on equity, there will be lower risk, and there will be lower cost of capital. And when there is a lower cost of capital, ladies and gentlemen, the business will operate better to attract cheap capital, and in the end, the profitability of that entity will increase. I want to thank you.
Thank you, Mr. Damulira, for those conversations on ESG. I think for most of us who are not accustomed to this ESG regime, do look at these concepts and imagine whether some of them are practicable or even if they are applied at all. Something I had in mind when you were presenting, Mr. Damulira, was because you did draw a comparison, especially with the UK regime compared to the Uganda regime. There seems to be a lot of scrutiny in the UK. There's a lot of regulatory intervention in the UK. And my mind ran straight to Uganda. Do we have this level of regulation? Do we actually even conduct audits? Because when you started talking about IFRS, I imagine now it's going to auditing. Do we conduct ESG audits on corporations? It might not even be financial institutions. In your experience, what have you witnessed in terms of audits and regulatory intervention in Uganda? This you could be answering as we are just waiting for the next speaker. And also, members in the audience, please use this opportunity as well to ask your questions, which I'll pick up and put to the speakers. But Mr. Damuria, please, if you can address.
Thank you, moderator. My experience managing compliance and the ESG, I noted that in Uganda, the organizations that are taking ESG very seriously are the organizations that are listed. You realize that the organizations that are listed on the stock exchange have a stringent framework on disclosures, especially on governance. Now, those organizations that have boards, the boards are required to have a committee on ESG. You'll find that several, even the banks, especially those that are listed, have a specific committee that is looking at ESG. Looking at ESG in twofold, as a requirement of the rules that govern their listing, and also as to look endearing. I said in my earlier statements that an organization that takes care of its environment looks very endearing out there. Now, so such organizations, the listed organization I am talking about, do it, one, to look endearing to the population, and also to observe the requirements under their listing rules. The other organization and entities out there that are not in the banking and they are not listed, the story might be slightly different.
So therefore, I get a sense that ESG requirements, especially for those companies that are not listed, it's precisely about the corporation's initiative to comply to some of these principles. And for me, that poses a danger or a risk, because if you leave it at the whim of organizations, we know principally any entities out there to make profit. And most of these ESG requirements are not necessarily profit-oriented, even when they can potentially be. So where do you see that risk headed? Are we only safe to say, okay, after all, we have listed companies complying to ESG goals, we can leave the rest of the crowd out? How can we balance that regulatory intervention?
Yeah, thank you. Thank you, moderator. My experience and thoughts in this area, as if we are looking at sustainability as a country, as an economy, it is not possible to leave out those other organizations. What would be important is for us to use that trickle-down effect. If the organization, the big organizations running the economy, say the banks, would be interested in the other organizations where they invest, where they lend. If the bank would ask questions, what are you, before you sit down with me and negotiate this lending, what are you doing in your environment? What are you doing in the place where you live? Where are your books? How good are your books? In terms of disclosing what you are doing in this area of ESG, there will be a trickle-down effect. Even when there is no biting, stringent regulation on that smaller organization out there, if it will find it very difficult to access lending, call it borrowing from the bank, the trickle-down effect will will happen. But I also want to say something about the cost of ESG vis-a-vis the benefit. In my consultants work, I have dealt with having to evaluate the cost. Should the organization comply with the ESG requirements with a high cost? If where is the balancing act, the cost of compliance? The cost of compliance can be very high for some organizations that are, especially those that are listed. The cost of compliance can be very high. But now, when you look at that cost, you must look at the bigger picture of the cost of non-compliance, including the impact it will do on out there in respect to how endearing you are as an organization. So it is not important to look at just the money, the money that you'll be spending. Look at the cost vis-a-vis how you look out there, and then make a decision on whether to comply, on whether to observe governance requirements or not.
And just before I bring in the previous speaker who spoke on Islamic banking, I'm still with you, Mr. Damlira, as I also wait for the audience to ask questions. Now that you talk about the cost of non-compliance, this is where I imagine the regulator will come in to, slump fines or whatever they can to institutions that don't comply to these ESG requirements. In your experience, and if it could be maybe for Uganda's case, have you had anywhere where there has been a fine or a penalty passed for non-compliance to ESG goals? Or is that something that is yet to happen? And if it does, what do you envisage the fines to be? What nature do you think these fines can take?
Thank you, moderator. We don't have to go very far. In Uganda, we have had organizations in very big trouble for failure to observe ESG requirements, especially in the areas of the environment. Colleagues, you do know that that the NEMA Act is very strict on how organizations are dealing with the environment. And right now, as we talk, enforcement keeps going on in the areas of the environment. The areas of social, there are suits that deal with rights, and so enforcement there is also happening. Now, in the areas of governance, the slippery one is the area of governance, because for it, it appears abstract in its nature and its value. People organizations may not look at it as something that will cause a direct reprimand in terms of what they do and what they do not do. But still, organizations have been reprimanded, especially from the angle of the listing regulators. CMA and USE has gone ahead to reprimand organizations where they fail to comply. So we don't have to be very far. It's really happening.
Okay, there you have it. So there is indeed a sanction if we do not comply to ESG goals. But I know previously I talked about the fact that ESG is not an area that is necessarily profitable. But I've also, in some cases, come to learn that there are actually products designed under the ESG perspective. I have heard of things like green bonds and all those products that are designed, with the ESG goals in mind. What are some of those products that especially our financial institutions can look at in the ESG space, but also maybe to even enable the ESG agenda to be advanced by its customers? Are there specific products that banks should be interested in that, for instance, us as lawyers should be able to advise our clients out there who are banks about?
Thank you, moderator. What are those products the banks should look at in the ESG space? In my earlier presentation, I opined that the best way for a bank to observe ESG requirements is to incorporate it in its structure at the point of lending. Firstly, if that loan agreement is compliant with ESG requirements, that will ensure that that organization that is coming for lending to that bank observes or makes attempts or makes some commitment to observe ESG requirements. We have just had a discussion on Islamic banking and how Islamic banking is very careful where the money is invested. It is not enough to just pick money and go anywhere. I'm thinking that our banks should be able to take interest in where the borrowers are taking the money, and there should be some undertakings at that stage of lending. Normally, a borrower is very soft at point of receiving money. They are able to undergo and make commitments. But after they have taken the money, you might have to go into a chase. So firstly, my first advice is that the banks should incorporate the aspect of ESG at the lending stage. The paperwork should include some commitments to ESG. Now, aside from that, there are those initiatives that the bank should be able to invest the money. I have seen some banks doing some trainings on keeping of books of accounts downtown. I've seen some leading banks investing in renewable energy, and I've seen a particular bank promising putting aside a loan portfolio for organizations that are investing in renewable energy. Now, the bank's tool of influence is money. Let me repeat. The bank's first tool of influence is money. So if the bank can use its money to say, you must observe these conditions before you take this money, that would be the case of the trickle-down effect I was talking about. Everybody would become compliant in the long run. And several others, invest in renewable energy, ensure that where you operate, if someone is dealing in modern day slavery and you are aware, there is no reason why you should not ask such questions when they come to seek for a loan. So there is a cocktail of things that banks can do, but most important, incorporate ESG at point of lending. Use what you have to be able to create some influence and guidance in the right direction. Thank you.
Thank you for that, Mr. Innocent. I do have a question, I think, in the Q&A. Let me bring that up. Just having some technical challenge with my computer here. Let me see if I can use my phone to bring up that question as the technical team is working on that challenge. Okay, here we go. As I dig up that question, here it is. And it does, this is Sheila Pakuto. I hope I have pronounced the name accurately. But Sheila asks, what does financing for the letter G, in the ESG look like? What would the lenders be looking to see? And secondly, she asks, do the banks in Uganda have internal ESG standards against which they can evaluate borrowers on ESG? I'll just repeat that one more time. A question from Sheila. Sheila asks, what does financing for the G in ESG look like? And what would the lenders be looking to see? Now, secondly, she asks, do the banks in Uganda have internal ESG standards against which they can evaluate borrowers on ESG? Mr. Damulir.
Thank you, moderator. Thank you, Sheila, for that question. I will start with, there are two questions, and I'll start with the second question. Do banks in Uganda have internal ESG standards to evaluate borrowers? Sometime if you look at the financials for the banks, like I indicated earlier, an institution will look very endearing when it propels a picture that it observes ESG. So when you look at the financial institutions' books of accounts, you realize that there is a segment on how that bank is observing ESG. What is not happening for sure is having to pick that metric and bring it down to the loan statement, to the books that guide the bank when it is moving into the loans, when it is giving out loans, when it is making a decision to invest in other organizations. But in their books, when you look at their books, you'll see that there is that segment. So what they would need to do, what the banks would need to do, is to bring that down into and incorporate it at point of making a decision. And therefore, because you see, lending is contractual, therefore, if it is contractual, you may not do an evaluation in respect to the parameters that you did not provide at point of contracting. So it's very important that at point of contracting, the banks will agree with the lenders on which parameters they will be checking as they keep evaluating that financing. Now, the second question is, what does the finance for the G, what does the G look like, the governance in a loan? My thoughts are that governance starts with the responsibility, the books of accounts. If an organization appears in a banking institution and seeks financing, my thoughts are the bank should be interested in its responsibility, its disclosures. What is it doing? What is it doing with its shareholders? What is it doing in its environment? It's aside from that. So I am thinking that the incorporation I spoke about of the governance, the responsibility into the loan or the financing documents would be the replica, would be the mirror, would be what would mirror the G that we are talking about here, the governance.
Thank you very much, Mr. Damolira. I think we will leave it there for now. I'm just hoping that members can still send in more questions in the Q&A tab. Just to let our audience know out there, we are having some technical challenge with the chat tab, so you'd better be in position to post the questions in the Q&A tab, because those I can pick up. I can't for now pick up those in the chat because of the technical challenge, but do keep those questions coming in Q&A. All the speakers are going to stay available to answer your questions even when they have spoken. And just as the next speaker comes on, I wanted to bring in Mr. Ahmed Senkumba, who presented on, you can just transfer the mic. Okay, who presented on Islamic banking. And specifically, I want to ask a question about reporting mechanisms in the Islamic banking space. Financial institutions are heavily regulated. They do a lot of reporting, not only on a national level, but if they are in a group structure, they will be reporting to their parent companies. There's all that structured reporting. So I want to understand if Islamic banking also adopts this nature of reporting. Remember that sometimes you will have a fully fledged Islamic bank, but other times you have a window of Islamic banking in a traditional commercial bank. I don't know if Islamic banking has that extent of reporting. If it is, would you please then be kind to highlight for us the nature of those reports that would be required under that regime?
Okay, thank you very much, Mr. Moderator. We actually stated that when we talk about Islamic banking, This is just an alternative system of banking, and ideally, it is not in any way different from the conventional system of banking. Therefore, Islamic banks will also be liable to the reporting standards. Specifically, you'll come to realize that there are various reporting standards which have been formulated for Islamic banks. And in a way, such banks comply with such reporting standards. There is the international reporting standards for Islamic finance, whereof they just consider Islamic finance generally, including banks and insurance companies. So you'll come to realize that Islamic banks will actually be liable to such reporting standards. There is a certain institution, also at the global scene, which is actually having its headquarters also in Malaysia, whereof they consider various acceptable reporting standards for Islamic banks. And the assumption is that Islamic banks, or banks offering Islamic bank products and services, either fully fledged or as a window, they will actually be required to abide with the same. You will come to realize that in that particular context, especially audit companies here in Uganda, we have many which have actually sent their employees to study about these reporting standards when they are preparing their financial statements. And I can confirm that we are having experts who have actually ventured into such area. And for them, they are saying that we have the necessary expertise in order to audit and even make reporting on financial statements of Islamic banks. So Islamic banks, they will actually be liable to such international reporting standards, most so which are formulated in light with Sharia principles at the global scene.
Thank you. Thank you, Ahmed, for the response. I do have a request from one of our panelists to actually also ask a question on Islamic banking. So, Mr. Damulira, please do ask your question.
Thank you. I'm interested. I know that you rightly put it that Islamic banking operates on the principle of profit and loss sharing, and I know that loss or profit will be determined upon perusing the books of accounts of an organization. I know also that the books of accounts of our organizations, many organizations, many entities are really bad. Someone who uses the word integrity. How, as we go into this area of Islamic banking, how are we going to ensure that we have books of accounts that have integrity? I'm sure that the integrity of the books of accounts will determine the profit or loss. So how do we ensure that that organization that the bank has invested in is not falsifying books, and therefore it is determining the profit or loss for that matter? Thank you.
Thank you very much, Mr. Damurida, for that question. And it's a notorious question, which even some people thought that, you see, Islamic banking, it's not feasible for a country like Uganda because of the nature how people do business. But the counter argument, when we are looking at the global trends, we actually stated that Uganda is not in any way different from our neighboring Kenya and even Tanzania, because Kenya developed the system way back in 2008, and in East Africa you'll come to realize that it's leading in this particular system. Therefore, when we talk about Islamic banking, ideally we are talking about ethical banking. In that, yes, it's well known that in Uganda, Ugandans prepare 3 statements, financial statements. There is one for URA, which will actually be reflecting a loss. Another one for the bank, which will actually be reflecting exorbitant profits for purposes of being given a loan. And the actual one. Now, when you talk about Islamic banking, this is ethical banking. The bank is not just leaving you only to venture into business without the bank's participation. Ideally, the different modes of banking which I discussed, for instance, Musharak, Mudarab, as the case may be, we are actually partners. The bank is partnering with you, whereof those are circumstances. In case venture it's actually a bit big, the bank will even depute its own person in order to supervise the daily activities of the transaction. Now, this being ethical banking, you cannot actually think about a situation whereof a customer is conniving with the bank in order to defraud the state of its revenue by presenting such what? No, it will not actually arise, because it is against Sharia principles and even the laws of the country. The bank has to protect its name. So under such circumstance, the bank is not just going to leave you in the business just to do whatever you want while just giving them information at your own leisure. No, the bank will also be participating. This is actually a partnership. That is why, in case some people have criticized this particular system, they are saying that, you see, when Uganda starts up Islamic banking, people are actually also going to come into our business. Actually, that is the major issue, because the bank has also invested money. And mind you, the bank, as we've seen the various accounts in Islamic banking, the bank has invested money of various depositors, which has to be protected. So under such circumstance, that is why as partners in business, the bank will actually be looking at every coin which has come in. In case there is a loss, it will also be explainable, simply because it is a partner in this particular transaction. So it is unlikely to find a situation whereof the bank is just leaving the management of the enterprise to a given person who has been financed, and the bank is just in the back seat. No, this is actually a partnership. Therefore, the bank will be involved in this particular commercial venture, knowing each and everything, and above all, to ensure that the transactions are being conducted in a transparent manner. And that is also the gist of the Sharia Advisory Board, which we hinted about, which is a requirement for every institution that operates Islamic banking products and services. Mr. Moderator, sir.
Yeah, thank you, Ahmed. And I would like to also thank our audience who are actively participating and asking questions. I do have a question here from the audience for you, Ahmed. I was keen to get questions from attendees who are in the banking sector. I see Rita Kavatunzi there from Stanbic Bank. Earlier I saw Bless Nkunda from GT Bank. I was anticipating questions from people who are actively involved in the bank. I also see Madam Rachel Musoke. Thank you guys for attending. But this question specifically comes from Patricia Kemirembe. I think Patricia is also actively in the bank. And the question is for you to explain the concept of interest on saving accounts. Ahmed.
Okay, thank you very much, Patricia. we actually stated that Islamic banks have various accounts, and there are major two types of accounts. The accounts are not committed to investment, and also the investment accounts. When we talk about accounts not committed to investment, we are having the current account and the saving account. And I stated that the current account is actually being operated in the normal way, like how conventional banks operate. The same way how a current account is being operated in Baroda, it is actually the same, whereof you just deposit money on the account, you are given a check, you withdraw, as the case may be. Then, for saving account, what we stated, that the customer deposits money on that particular account, and the bank has convenience utilizing that particular money for investment purposes. In that, in case the bank has utilized the money and the bank has actually made profits arising from such customers' deposits, we stated that according to Islamic law, that particular customer can actually be appreciated by giving something called hiba. Hiba, it is just like a gift, whereof you are actually given something as a token of appreciation. Maybe an amount depending on the amount which you deposited with the bank. So the distinction between this particular gift and interest, when we talk about interest, in case you have fixed money on a fixed deposit account, the interest is actually guaranteed at a given rate. It will actually be well known. However, this is not the case, in that you can actually put money on a savings account and you don't get any return from the bank. However, it is just at the discretion of the bank. That is why we are calling it a gift. In Islamic banking and also Sharia rules, it is actually being considered as a gift, as a sign of gratitude for having deposited the money with the bank and the bank making some good profits out of that money. Therefore, you cannot take the bank to court on the basis that you deposited money on a saving account and yet the bank has not provided you with a return. It does not arise in Islamic banking. So that is why we are not calling it interest. This is not interest because it is not predetermined and there is no guarantee about it. It is just like a gift, whereof, for instance, you've actually done something good for a given colleague and the person appreciates by providing you with a gift. In case the person has not provided you with a gift, you cannot actually take that particular person to court. So this is actually the gist of saving accounts in Islamic banking, in that in case you wanted a return, then you must actually channel your money to saving to the investment account, whereof you even maybe restrict that I just want the money to be invested in agriculture or real estate, or in the alternative, you just make it unrestricted for the bank to decide where to invest the money. That is actually the major distinction.
All right, there you have it. Thank you, Ahmed, for that question. I would like us now to really move on to our next speaker, seeing that we are trying to catch up with time. And our next speaker is going to be Mr. George Otim. Mr. George Otim is a manager, corporate finance at BDO East Africa. And he's going to be discussing the topic fostering growth and specifically access to affordable credit as a vital financing option for businesses in Uganda. You realize that the key obligation, or rather the key role for banks in any economy, is to make finance available through through credit. So we expect Mr. Otim to discuss aspects of access to credit from financial institutions and how this can foster growth in the economy. Ladies and gentlemen, welcome Mr. Jojo Tim.
Good morning, everyone. Yeah, just like you said, I'm George Jato Tim. I'm a manager at BDO in the advisory department. I lead corporate finance in particular. So just as the moderators mentioned, I'm here to discuss the topic fostering growth, access to affordable credit as a vital pricing option for businesses in Uganda. So let's wait. Okay, so we'll look at the overview of debt financing generally in Uganda. It's important to recognize the fact that micro, small and medium-sized enterprises account for about 70% of the country's private sector production. So one key thing to understand is how do they access capital. So debt, as you've seen over the last 5 years in our market, has grown by 25% year on year, reaching an impressive 2.5 billion in 2022. However, if you look at the World Bank Group's enterprise surveys, only 10% of firms in Uganda have a bank loan or a line of credit. So they still massive growth to be achieved in that aspect, given that we are among the least performing, countries in sub-Saharan Africa. Debt, in terms of its benefits, it's a quicker access to capital, and then can help you also meet your expansion and strategic investments. So in terms of making it affordable, key thing is to understand how the pricing is done. Now, the first item that is considered, which is the base rate, from which the cost, which is the interest rate, is determined when you approach a bank as a business or as an individual. The first reference rate that is taken into consideration is your central bank rate. At the moment, I think it's about 9.5%. And if you look at the average lending or borrowing rate for a business here, that's more or less 45 to 50% of the cost at which you're going to borrow money from a bank or any other institution. So it's quite important that to keep tabs of that. So if in situations whereby it's less or it is dropped, then it makes it favorable for businesses to borrow. Second item is the credit worthiness of an entity. I don't know how many people in this room have financial cards, by show of hands. It's impressive. So people are actually borrowing, yeah. So how an institute is able to establish your credit worthiness is obviously by you having access to loans. So you don't need to have a financial card as per now. But I reckon based on the recent changes as per the regulator, is that very soon we'll be making that migration from financial cards to national ID as a basis of determining, the credit worthiness from the credit referencing bureaus. And then to add to that, well, once the transition is made, then it will make it a lot easier, I think, to keep track of how every individual business is. Oops, screen is off. Sorry. Every business is doing. So next would be the loan type. So what type of loan are you actually going for? And what its purpose. So is it going to be straight debt in that reference, or are you looking at perhaps is it going to be a fixed interest rate, or is it going to be a variable rate? So all those have to be put into perspective. Then the term of the loan is also important. Is it going to be a short-term facility or is it going to be a long-term facility? By short-term, you're looking at a period less than 12 months, and then long-term, probably 3 years and above. Inflation, which also feeds into the central bank rate, is quite also a key indicator of what the lending rates are most likely to be. In an environment where your inflation is quite high, then ideally your central bank rate would be going up, and then the cost of borrowing would be high for you. We have also the lender's policy. So this varies from institution to institution, depending on how they go about, how they also, the cost of finance in terms of what interest rates are they giving to their borrowers. Are they funded mainly by development finance institutions? Have the shareholders also put in quite some amounts of money, meaning that they'll be requiring a higher return? All those will have an impact on the spread, the interest rate spread that the banking institution is going to earn. Economic conditions would relate to generally how the economy is performing. If it's struggling, then ideally it would mean that you would have difficulty also accessing capital. Collateral is also quite important. I was recently advising a client, and they were earning revenues, give or take, about 1.5 billion, had operating expenses of about 500 million, and had land on their balance sheet of about 2 billion, which was quite idle. So when we investigated and tried to understand why is it so that they have quite a huge chunk of capital tied up in an immovable asset, and that is not in use, and they said, well, the reason as to why they acquired it is because they wanted to use it as collateral when they are accessing capital from the banks, which I feel wouldn't have been ideal, because in terms of cash flows they were struggling. So I had to advise them to consider maybe buying bonds, which are also acceptable by most banking institutions as security. And the fact that they are highly liquid, it would also impact on the pricing of your loan. So they eventually decided to sell that land and help them generate also interest of their bond, and put some of the money also in a unit trust. So give or take, of that 2 billion in a year, they would be making about maybe close to 200 million as their interest rate, and that 200 million would probably also cover about 40% of their operating costs, so which was quite helpful. And then competition as well plays into the pricing as well. The banks are always aware and keeping tabs with what their competitors are doing in terms of them being in the same tiers, or looking at institutions in different tiers, as well as other sources of capital. Then government policies, if the government is not spending, then ideally that means there's no money in the economy. I bet that's what we're experiencing now, because the quality of our roads is quite bad. There's so many potholes around. Yeah, so leave alone the pricing. Now we need to also be take note of the partnering issues that you need to consider before you take on debt. And the business stage, you'll notice that startups it wouldn't be an ideal for a startup to take on any debt, or probably they'll take on smaller loans, simply because it's not yet certain whether the businesses that they are running are eventually going to be successful. So there's a lot of uncertainty there. Then they should be exploring maybe equity or other forms of capital, or grants, etc. But then once it's to mature stage, then ideally, and you're being able to generate some cash, that means that you'll be able to facilitate payments in terms of obligatory payments, in terms of interest and principal repayments over time. So ideally, you can go on and take on some debt at a later stage when the business is mature. Then also cash flow status, businesses that generate cash flows consistently are quite sustainable, then that means that they can easily raise debt. Then for those that have fluctuating cash flows, then it would be imperative that you discuss with lenders who are able to factor in the nature of the cash flows of the business. So perhaps they will have to charge you interest either monthly, quarterly, biannually, or annually, depending. Then again, the use of funds. So the funds have to be aligned to the strategic objectives of the business and avoid unnecessary debt. I myself am a culprit. I think those who are financial cards in here can also perhaps also indicate whether all the money they borrow is eventually used for its specific purpose. Perhaps you take some off and get yourself a really nice watch. So that's a habit that is not really good. Then when is it, like I said, just need to take advantage of growth opportunities, look at funding in terms of expanding your projects. Then when is it not appropriate? Like I said, when it's early stage, and then also when it's an early stage opportunity, and if you have other access to other sources of funds, then that will be helpful. Then brief overview. Like I said, businesses heavily rely on debt, and commercial banks are believed to fund about 70% of the loans that are in our market. But then there are also non-bank providers of debt. So you have development finance institutions. Mentioning a few, in Uganda, I think you're familiar with UDB. You have ABI Finance that funds purely agriculture, nature projects, IFC, DFC. So they're quite stringent in terms of the requirements that are needed, but they offer concessionary loans, and they may be cheaper than what the commercial banks are offering. Microfinance institutions ideally offer slightly expensive debt, but it's easily accessible compared to the development finance institutions and commercial banks. You have private equity firms. I'm mentioning equity here, but some of these firms also offer debt products, and I think some of those that are operating in our market are Ascent Capital, XSML. It's worth speaking to them before you make the decision to eventually borrow funds from an institute. Then we have fintech companies, and most of the traditional banks are actually taking this route. Is where they are becoming, they're looking at investing in the fintech space, and it's an area that has been of immense growth for them in the last couple of years. So then debt sizing, when you're trying to assess how much debt you should take on, it's important to keep tab of your debt versus equity. So equity is what the shareholders are contributing into the business. The more equity you are, the more equity you have in your business, the less likely you're going to struggle paying up your debt. So and also if your debt levels are quite high, then your shareholders are going to be worried, so they probably ask for a higher rate of return. So that's quite important. Then the other ratios you'd consider would be things like your debt service coverage ratios, which are and interest coverage ratios, which are ideally ratios that give you an indication of an entity's ability to pay interest and principal repayments from its business operations. Also, having a really well-developed, robust business plan also helps in terms of helping you have access to cheap capital. Then your cash flow analysis, like I mentioned, is also quite important. So if you're cash rich, then ideally it makes it it improves your chances of meeting your debt repayments. Lastly, you have there the quality of your financial statements. I'm an accountant by profession as well, qualified accountant. So and I do also analysis, so I have an idea of how the accounts are prepared, and I analyze them on a daily basis. So if the quality of your financial statements are quite robust, and you're not depicting a loss as the previous speaker had mentioned, then that means that you stand a chance of having access to quite a sizable amount of debt, and it coming in at quite a cheap cost. So that's where my presentation ends. I welcome any questions at this juncture.
Thank you very much, Mr. Otim. I think you'll have to wait a little longer for the questions. We lawyers are friends with accountants, but we take time when we are with accountants. So
that's why I tried to limit the number, the figures I had in my presentation.
Yeah, sure thing. But we do have a Q&A session just after the last speaker as well. But we will also have a couple of questions coming in through the chat and the Q&A tab. I will also be picking on those, and we answer them as we go along. Now, one of the speakers unfortunately has to leave, but they have a question in the chats, and I requested that they do attend to the question before they take leave. Ahmed, I think you have one from here it is, still from Patricia Kenny Rembe, and she asks rather politely, "Dear Ahmed, given the level of involvement required of the lenders in the business of its borrowers, is this model of feasible?" I think she asked, "Is this model feasible for microfinance banking, owing to the number of customers in this sector?" I think from the background of this question is that the Islamic banking aspect really calls for partnership between the customer and the financial institution, to the level of even having to share profits or losses. And that involvement is what she worries about because of the sheer numbers in the microfinance banking sector. And she's asking, is this feasible? Ahmed, if you could take that on. I don't know if the mic can get to you there.
Okay, thank you very much, Patricia, for that question. Regarding microfinance and Islamic banking, you'll come to realize that already here in Uganda, the Microfinance Support Center has a section of Islamic banking, which I'm aware of, being headed by Dr. Luja, and they are already in business in that particular direction. So, in this particular arrangement, Islamic banking and microfinance, there is no distinction as such, because already it is being practiced. But I will also just add that maybe the background of this particular question, you come to realize that in most circumstances, the Islamic bank partners with a certain customer, and they actually share profits and also losses as the case may be. So what we stated that provided your major aim is about commerce, it's a commercial enterprise, you just want to go into business, then you should actually open up for profits and likewise losses. However, In case of Islamic banking, and it is realized that the intention is just to uplift the status of these poor Ugandans, especially what we are looking at with the government operation wealth creation, among others. Those circumstances whereof someone will actually just be given money and that particular person is just requested to return the same amount without any markup, without any interest. So under such circumstances, it is not about business, but just intended to uplift. Some of the issues which have been raised more so with operation wealth creation is that, yes, these people are being given money to uplift their status, but they have to return the amount and also with the interest, which is actually ideally not in conformity with the practice of uplifting people's what status. So what we are trying to say is that already regarding microfinance, the Microfinance Support Center has a section of Islamic finance. It is actually not Islamic banking, but Islamic finance, which is being headed by Dr. Wujja, and already they're in business, whereof people are actually getting small loans, and they are in position to pay with profit in case they have made profit, or in case there is a loss, automatically. But under such circumstance, again, the strict principle is that there will actually be auditors who will be monitoring the transactions on a weekly, a daily, monthly basis, without just leaving it to the customer at the end of the day to say whatever he wants or report to the institution as per his own choice. That is actually the cardinal aspect in that particular regard. So the aspect in respect to Madam Patricia's concern, we are saying that already the Microfinance Support Center of Uganda has a department for Islamic finance, whereof people are even getting finances according to Islamic principles.
Thank you very much, Mr. Senkumba Ahmed. Ahmed does request that we release him as he's going for Juma prayers. As you know, it's Friday, and Senkumba adheres to a very strict Muslim faith, so we'll have to excuse him for now. Do still post your questions. We will get these to him even when he's away. Remember that the presentations are going to be shared with you on your emails. So for any questions that you still do have, we'll get them to Mr. Senkumba. But for now, we do have to let him go, unfortunately. But thank you very much, Mr. Senkumba Ahmed, who is the head legal at Bank of Baroda, and a master's student. You got the master's already?
I got the master's student. I'm also a lecturer of law at the University in Uganda.
Quite a handful, lecturer at Islamic University of Uganda. Already got his master's in Islamic banking, head legal at Bank of Baroda. Thank you very much indeed, Mr. Senkumba Ahmed. And do remember to pray for the banking law cluster. Yes. We are moving on to the next speaker, but I wanted to first bring in Otim on a couple of aspects that you presented about. If you could just take the seat for the mic. One of the questions that I want to ask, and this is because previously I used to work for a financial institution, and I see a couple of my colleagues who are still working for the banking institution. I see Brenda Chokwijuka, I see Rehuma Nabunya and Kandi Okoboy. They could have encountered this situation. I know we would advise our clients then, our clients who are the banks, when they're drafting their contracts, not to make the purpose for the loan their concern. Would simply say the bank is not going to police you or monitor you on the purpose for which you use the loan. And now when you were presenting, I felt a little guilty. Shouldn't the bank be concerned though? Because the purpose for which you take the loan essentially determines its performance. You could be taking on the loan for, like example you gave, to buy a fancy watch, and the possibilities of paying it back might be very challenging, especially because financial institutions lend you according to your capacity to pay back, and that of course depends on the business you do seek to venture. So should banks focus or police customers on the purposes for which they take the loan?
Thank you. I think it's quite important. I'm not so sure. Is it at the point where you're drafting the contracts that you wouldn't indicate? But prior to that, I'm sure by the time you get to the point where you're drafting a contract with a potential customer, you would probably have done some sort of like due diligence and an assessment as to whether this business is going to have the ability to pay. So one of the requirements at that point is ideally just trying to understand if they have a really good performing business, then what is the money going to be spent on? So you'd have to really understand, and in some situations you find for some of the entities I've dealt with, you find that the lenders actually participate in the for instance, there's a client who we're working on who was bringing in medical equipment, so they really had to get involved right from the procurement until the equipment was installed here in Uganda, and keep tabs on how the business is performing towards meeting their debt. So I feel it's very important for them to do it. I'm not so sure whether they do it at the moment, but it's quite important for them to do so.
Oh, thank you very much indeed. It should be. I felt that when you were presenting, but not in the manner which you have answered, because why we would encourage them not to focus on the purpose is because, yes, we would know that a financial institution is giving you the loan perhaps to set up a plant. But if you do take that loan and do a completely different things, that shouldn't be an excuse for you not to pay back. Maybe I think that's the light in which we were advising the financial institutions. But whichever way it is, I think it does make sense that the banks mind about the purpose for which customers take the loan. Just one final question before I go on to the next speaker. You did talk about a lot of considerations that financial institutions look at before they advance credit. And I seem to recall a couple of those considerations related to governance, things to do with ownership of the customer if it's a corporation. And I ask this because there's an interesting judgment that I read, and the judge in that judgment seemed to say that, because I'll give you a background, it was a matter, it's a land matter, a company owned land, and the allegation from the plaintiff was that they did own the land illegally because the company's management at the time, undertook some fraud to get to own the land. And so the question was really about fraud performed by management then. And the judgment seemed to say at some point that because the case came much later, the current management had changed. There were different directors altogether. And so the judgment seemed to say that there is no way you will attribute the fraud that was committed back then to the current management simply because the current management did not involve in fraud at the time. But then a company is a company, whether it's managed by a different director now or later in the future. If it does commit something, that should run with the management, even if it's a new management. So to what level should financial institutions get concerned about the change of ownership for these different customers? Should they even mind about it? Because the company is a separate legal entity. Yes, it is run by individuals, directors who make decisions for it, but it stays a corporate. And whether management changes or not, the decisions that were taken impact the company as a corporate. Should financial institutions mind at all about change of ownership and these other governance issues?
I do reckon that's very important, and usually companies that have a well-constituted board tend to. It also contributes to actually lowering their cost of capital. So give or take, if you're looking at maybe an entity of equal size to a listed entity here in Uganda, you know that the governance of a listed entity is quite top notch, or is heavily scrutinized by the regulators from the sense of the market on which they're listed on, the Securities Exchange and the Capital Markets Authority. And if it's probably in the banking sector, then also it's going to be it's going to ensure that most of the directors there actually and management are vetted in the positions that they take up. So that ideally also increases the confidence of the lending institution, and give or take also the lending institutions also have well constituted boards. So ideally, if that's the case, then it would lower your cost of capital in the long run. Yeah.
Thank you indeed, Mr. Otim, for those very resourceful responses. I do encourage the audience to still participate and ask questions to Mr. Otim. He's going to stay around until the last speaker for the Q&A session. But thank you very much for now, Mr. Otim, for taking us through that. I would like now us to move very fast to our next speaker. It's an interesting time to be alive in the banking sector, considering the level of litigation and whatever is happening in the courts regarding the financial sector. And to discuss these aspects, we have Mr. Jude Byamukama. Mr. Jude Byamukama is a partner at J. Byamukama and Company Advocates, and he has pretty much been involved in most of these decisions that courts take regarding financial institutions. And with him, we will be able to see some of these decisions. How have they impacted the financial sector? What has been the role of the ULS in developing this jurisprudence? So to discuss the recent court decisions in the banking sector, Mr. Jude Byamukama, please welcome to this platform. And just to remind you, we are still hosted by the Banking Institute at Buganda Road, who are very generous to grant us premises where we're streaming live. And we are doing this as the banking cluster under the Uganda Law Society. We do encourage members to join the cluster if you're interested in banking and finance and the trends, to keep up with the trends in that sector. Please do join, express interest in the sector. We will be glad to have you. And for those members who were not here yesterday, fear not, because these presentations are going to be shared on your emails, especially because you have subscribed for this event. This is a CLE points accredited event, so whoever is attending at the moment, you will be certain to get your 10 CLE points, which are, as you know, vital for the renewal of your practicing certificate. Members who want to speak just sidebar me, send me a chat in my inbox. I'm going to request the technical team to unmute you, then you can be able to make your contribution. But for the rest of the discussions, please feel free to utilize the chat function on your Zoom, but also the Q&A tab for questions that you require to be answered. I hope now the technical team is ready with the presentation of the next speakers so that we start off. In the meantime, Mr. Biamkam, I know some of these things, you know them off cuff.
Yes.
You could be highlighting to us briefly what are those hot cases that have been decided by the courts. What perspective have the courts taken, and how has this impacted us as the banking sector?
Thank you. Obviously, the banking sector is one of those sectors where which feed, I think, and we could say which feed and live off litigation and the courts of law. And I've listened to quite a number of impressive presentations here about credit. And you know, one of the important factors about the cost of credit within an economy is the extent to which loan recovery, for example, is able to proceed without a hitch. And even under the controversial World Bank cost of doing business standards, they usually look at enforcement of creditor rights is a very important part in an economy. And so as we look at these decisions, it's important for our listeners and participants to understand that perspective. Because we always have that debate about the extent to which courts of law should kowtow to the demands of the banking sector, so to say. And quite a number of decisions, as we shall go through, you'll see that, yeah, there is some significant deference to the interests of the banking sector from the courts of law. So, the decisions we are going to look at, which we are summarizing from my working definition of recent, obviously is not last week. It's I think of something like 3-4 years, a 4 years cycle. It's quite important. I've also put an important disclaimer that we should be mindful that some of the decisions that we are going to look at may be subject of pending appeals. In some respects, I know for sure some are subject of pending appeals, some are not subject of pending appeals. However, a decision, even if it's subject of a pending appeal, there are those decisions which are so important that it's good to know about their existence. And obviously, I will refrain from commenting on the merits or otherwise of some of those matters which are pending appeal. But sometimes things are a bit obvious. Something is either legal or not illegal. No amount of appeals can change certain things. But I've given that disclaimer. I hope that members take note of it, that some of the decisions we are going to look through are subject of pending appeals. So the position of the law in them may change. We still have a legal system, and the courts of law are still a bit unpredictable. Not everything is predictable in terms of the law, and therefore we have to be mindful of that. So, we'll start off with the simple ones. We had quite not a very widely recognized decision, but we'll look at the High Court ruling in favor of the Centre of Bank of Uganda's directives discouraging and stopping recognition of cryptocurrencies. That is Silva Kayondo, of course, is an advocate with a lot of passion and interest in that whole area of cryptocurrencies and the digital economy. Silva Kayondo versus Bank of Uganda, that was a simple judicial review application. recently decided, but it's the complaint of Council Silva Kayondo obviously was that it is illegal and irrational for Bank of Uganda to discourage the recognition of cryptocurrencies and require banks not to recognize cryptocurrencies and then dealing with them. And so it was not dealing with the actual, are they illegal, are they not illegal? That's really not the question in that particular case. But the question was, if Bank of Uganda has chosen to take a stand that is not friendly to cryptocurrencies, is that reasonable or is it not? And the High Court rules that, well, Bank of Uganda was within its powers and didn't abuse them, and neither were the directives not to recognize cryptocurrencies illegal or irrational. So that's important, just to place as the growth in cryptocurrencies continues. And also maybe we'll mention in passing that as people continue to be defrauded through the use of cryptocurrencies, it's always important to know that they may not be able to run to the central bank for help. Because I think in some economies, one of the debates that happen, if people get defrauded using cryptocurrencies, do they have recourse, or is it a buyer beware kind of thing? It's a question that continues to arise in some countries. But at least in the Ugandan context, we know Bank of Uganda has taken an understandably hostile attitude towards cryptocurrencies. We wait to see. Of course, technology always moves further ahead of the law, and it's understandable because the law comes in to regulate what already exists, and it's usually difficult for the law to regulate what does not yet exist. And so maybe eventually the attitude towards cryptocurrencies may change, but we know globally that most central banks, most regulators are deeply skeptical to cryptocurrencies, and others are openly hostile to them. And that's the context in which we must look at this ruling of the High Court, agreeing that the Central Bank of Uganda's directive prohibiting recognition of cryptocurrencies is not unlawful. And then maybe what is quite important and going to be a bit controversial is this: with the prevalence of digital fraud in the banking sector, the question has been, particularly with the advent of mobile banking, who bears the loss for digital fraud? We have all these cases all over the place of people waking up one morning and they go to transact in their banks and their accounts have been swept clean. And then when someone goes to check, they realize that someone probably activated the agency banking, or someone activated mobile banking and has been withdrawing money on their behalf, and the account is dry. There's no money. Someone had 100 million and the account now has 2,000 Uganda shillings. The question has been, this is obviously something for the banking sector, but it has an interplay with the telecom sector as well. It's because obviously there's a bit of convergence now between the banking sector and the telecom sector, especially with the advent of digital banking and then mobile banking as well. So the High Court decision of Ida Atiku versus Centenary Bank gives quite some comfort to banks. And the High Court basically ruled that bank customers have a duty and responsibility to keep banking information, user IDs, passwords, and their what we usually call PIN numbers, although of course PIN is the personal identification number. PIN is confidential, and that in default, any fraud resulting from such omission or negligence cannot be visited on the bank. What happened in this particular case, obviously we don't have to get into the particulars of each case because we have to, the principles are more important than the particular facts. But in this particular case, the High Court ruling that the plaintiff, who was a bank customer, is one who was guilty of either negligence or was complicit in giving away her confidential PIN number or whatever, that led to withdrawals from her bank account that she insisted were not, she did not know about them. And so obviously, banks must always caution their customers. Some of them do it, at times they may not do it very well. Maybe it can always improve. That pins are very private. Passwords are private. And then obviously, banks also must have a security system that whose verification should be should show that it's above. They have made the effort to prevent fraud. But the important principle being that bank customers also have the duty to make sure that they are keeping their bank information, user IDs and passwords and PINs quite confidential. And that should they be careless about their passwords, should they be careless about their PINs, and enable fraudsters to access their accounts and withdraw funds from there, they cannot seek to turn to the banks for recourse. So obviously this can go either way, but the principle is quite important, and it protects banks obviously, because now banks know as long as they have done enough to prevent fraud on accounts, customers must also do their part. There's always this whole issue of people who keep their passwords written somewhere or in their phones and things like that. Or people who share their phones and yet maybe the phones have no codes. And as we now know, most mobile phones can be used to transact banking of unlimited amounts. And that has been a problem. And probably this, with digital fraud that's ongoing in very many institutions, bank customers have a role to play. And in the context of this decision of IDATIC versus Centenary Bank, decided just, I think, a year ago, it's critical to understand that bank customers have some role to play in preventing digital fraud. And then we have had this whole issue of banks have been having a very uneasy relationship with their borrowers, especially. There's been quite a bit of mortgage fraud in the past several years. The commonest form of mortgage fraud that seems to afflict many banking institutions is a collateral that is declared by the borrower to have a first sale value of 1 billion. And then later, after the borrower has defaulted and it's time to try to realize the security, the collateral is worth 200 million as a first sale value. Why? Because the borrower may be colluded with the borrower to exaggerate the fair market value of a collateral and its first sale value. The courts have ruled such borrowers are liable to indemnify the banks for the entire sum of the loan amount that a bank may have lost as a result of that negligence or fraud of the borrower. And for borrowers, obviously, it takes on two dimensions. Because typically borrowers have service level agreements with the banks, so there is an element of breach of contract, and then there's also, in other cases, maybe negligence. Maybe a borrower is also very busy, because typically some borrowers a borrower has maybe 20 properties to visit in a couple of days, and therefore because the borrower knows, I know a plot in Muyenga obviously is of 10, 15 decimals must be worth 500 million. So the borrower puts a market value of 500 million, a for sale value of around 350 million. And that maybe the plot is partly a road, and then partly this, it's a whole mess, and the plot probably is worth 150 million. So if a borrower does not visit the site, for instance, and then makes a wrong valuation, that may not be breach of contract directly, but may be negligence. So still a borrower would be liable in negligence. That is the gist of the decision in KCB Bank Uganda versus Edin Samba and the others, civil suit number 640 of 2013, which was decided in 2021. It's not the only one. There's a host of decisions holding bank borrowers to account. And so it's an important development. And so obviously the borrowers who might be paying attention, there are quite a couple, I've seen a handful of lawyers who are also borrowers, need to pay very close attention to the emerging jurisprudence in this area, that careless valuations can have legal consequences. And the banks also need to know that they have recourse If a borrower's collateral has been grossly exaggerated, then the borrower may be liable to the bank in breach of contract and negligence. That is the crux of that decision of KCB Bank versus Samba and others. I've just picked one out of the many, but there are over 5 decisions on this particular point. And then staying with the subject of fraud, when we talk about credit facilities in the banking sector, fraud is there's always going to be fraud. Either the banks are being accused of fraud, or the banks are accusing the borrowers of fraud, and sometimes both of them are guilty of something. But here we are looking at fraud, especially committed against banks through the use of spousal consents. There is quite a bit of jurisprudence also in this area. Many borrowers sometimes want to go and borrow money, and maybe he wants to borrow money. He's not sure the wife is going to agree because he wants to pledge matrimonial property. So he gets a mercenary and he takes her to the bank as his wife. Basically, impersonation of a spouse to procure a spousal consent. Obviously, that is fraud, and it can have consequences. However, there is also an interesting dimension to do with, which is what is important in this case of Christine Kanyima versus Mercantile Credit Bank, which is the test of what constitutes matrimonial property. There is always a debate. This decision of Christine Kanyima versus Mercantile Credit Bank, Miscellaneous Clause 85 of 2021, it deals with this particular issue of what constitutes matrimonial property. Is it what the parties believe, or is the test objective? And the High Court rules that the test is objective. In other words, someone may believe this is a matrimonial property when really it isn't. I know there are all those instances of, for example, someone knows I cannot transact in this property without informing my wife. But maybe it is some arcade downtown. But because these are people who know they cooperate, they are business partners in some way, so the man knows I cannot, if I want to sell the arcade, obviously I need to let her know. And then maybe for some people, they end up having spousal consents of that kind. And the High Court is saying the test for what constitutes matrimonial property, in fact, is objective. That there may be cases, such as the present one, which was being discussed in the Hope Christine Kanyima versus Mercantile Credit Bank, where a party may believe that a particular property is a matrimonial property, whereas not. And in fact, on the facts of this particular case, the High Court Judge, Justice Stephen Mubiru, ruled that the property in issue was in fact not matrimonial property, and therefore dismissed the contentions of a spouse who was challenging a mortgage created on that property, following impersonation of her person by her husband. So there was fraud in this particular matter. There was impersonation. But the judge rules that there is impersonation, but that impersonation does actually not affect the mortgage, because although the man and maybe the bank all mistakenly believe that this is a matrimonial property, an objective test of what that property does and the relationship between the two parties confirmed that in fact it wasn't a matrimonial property. Obviously, the facts are extremely unique of that scenario. The spouse who was complaining, in fact, I think in the facts of that case, does not live in the country for the last nearly over 20 years, does not live in the country. And therefore, the test of residence, is she a resident in this property? She couldn't pass that test. And so the judge took the view that, yes, although the man did wrong, committed a fraud in fooling the lender about who his spouse was, the mortgage remains valid because at any rate, that was not a matrimonial property. Obviously, this is something that the bankers will receive with a lot of joy, and because it gives them an extra layer of safety when there is fraud in cases of impersonation of spouses in mortgages. And then maybe in not so good news for the lenders, and what will obviously be what the borrowers will have received with excitement, the High Court ruled that in light of section in Leshego, I know there is a better pronunciation of that word, but let's call it Leshego Uganda Limited versus Felix Kolaije, originating summons 5 of 2020. The High Court ruled that section 28 subsection 1D of the Mortgage Act 2009 and Regulation 10 of the Mortgage Regulations 2012 require that a mortgagor must specifically consent by notice to a sale by private treaty. And most importantly, that such consent cannot be retrospectively issued through recourse to the terms of the mortgage deed. So there are 2 points here. There has always been an argument. Obviously, a foreclosure. Can the mortgagee sell by private treaty? The answer in the law is yes, if the mortgagor consents to that arrangement. Private treaty means you don't need to advertise the property. There will be borrowers who, because of their reputation and standing, or because they don't want other banks to know about it, there will be borrowers who agree with the lender and say, look, I'm permitting you, if you have a buyer, sell that property, no need for an advert. I don't want my name in the media. So a borrower may permit sale by private treaty, and that will be lawful. The point of departure is, in this decision, and it makes quite a lot of sense, it's one of those that I wonder whether it was appealed, I'm not sure, but I think it makes sense. The position of the court is that consent can only be given when it is now time to sell. The argument of the lender was that consent was given by the borrower the moment the borrower signed onto a mortgage deed which had a clause permitting sale by private treaty. And the judge disagrees with that and says, no, that is retrospective consent. You cannot use a mortgage deed signed before an incident of default happened to say, because the borrower signed the mortgage deed in 2015 that had a clause saying sale may be by public auction or private treaty at the discretion of the lender. That cannot be used 8 years later to say, oh, 8 years ago you already permitted us to sell by private treaty, which we are doing. We won't be advertising. Sorry about it. We are selling it so and so already. And the High Court judge rules that is obviously prohibited by section 28(1)D, which requires a public auction of a collateral, and Regulation 10 of the Mortgage Regulations 2012. So obviously this is a decision that the lenders have to take note of. Otherwise they could end up with an invalid sale, and the consequences of an invalid sale can be unpleasant, as we will find out, or as in a number of other decisions have pointed that out. So leaving that area, one of the other debates that continue to remain, especially with the closure of some banks, has been the relationship between the Financial Institutions Act and the Registration of Titles Act. The question that was tested in Mera Investment Limited, which is this is a few weeks old decision, Mera Investments, I don't think it's been more than 2 weeks, versus DFCU Bank and another. This whole question of if the central bank, if Bank of Uganda closes a bank and sells it to another commercial bank, what's the status of these branches? In the facts of this matter, the plaintiff company was the lessor of particular properties which had been leased to Crane Bank Limited. And the question was, once those branches were taken over by DFCU Bank, wasn't the lessor entitled under the lease agreements to first permit the takeover of those branches? It's a question to do with terms of a lease. If a bank branch has a lease agreement, a bank branch has a landlord. If the central bank takes over that branch, can the central bank, without consulting that landlord, say, oh, you have a new tenant by the names of so and so, everything else is still the same? It's a question that I still think there are good arguments either way. I wonder whether it's been appealed. Maybe it will be, maybe it will not. But obviously, there are two laws at play now. The central bank is using its powers under the Financial Institutions Act 2004, not 2005, I think there's a typo, 2004, to transfer assets of a closed bank or a distressed financial institution to another institution. The question is, that transfer of assets happens because the central bank is exercising its powers under the law. Do those powers override our land law, especially our Registration of Titles Act, which also provides that a lessee cannot sublet or cannot transfer the lease to another party without consent of the lessor? Do the central bank powers override land law to that extent, because they're exercising powers to take over and transfer assets from one bank to another? That's a question that the High Court has chosen to rule in favor of the lessor. In other words, the High Court ruling that the Registration of Titles Act, which is the key legislation governing registered land, takes precedence over the Financial Institutions Act in that regard, because the Financial Institutions Act is also equally silent about that kind of scenario. Obviously, maybe that's an area that we'll have the regulator, the Bank of Uganda, and the legislators thinking whether there is a need for law reform over that particular question. I think it's a weighty one, and we'll wait to see what happens, but that's the current state of the law on that particular point. Leaving the High Court, we'll move a little faster. At the Court of Appeal, there is an important decision which is worth looking at in some detail. As I indicate, this is a matter that is on its way to the Supreme Court, but still I think it's so important, both for the bankers and for external counsel of banks to take close note, and then also for counsel for borrowers to look at the decision carefully and see what they can, whether their clients can take home something even if they're in default and the mortgage and the banks have realized the securities. That's Barclays Bank of Uganda versus Gulf View Inn, which was decided by the Court of Appeal on the 4th of August 2023. It has a number of important points. Let's just go through them just quickly. Firstly, the Court of Appeal upholding the position that service level agreements between banks and their external counsel governing remuneration in debt recovery cannot bind borrowers or third parties. In other words, as external counsel with a bank, obviously the bank tells you, you agree with the bank that you are paid a percentage of what you recover. When a bank gives instructions to commence a recovery process against a borrower in default, counsel knows they are entitled to recover 6% of the total debt recovered. The question has been whether that is lawful. If the borrower pays 1 billion, can counsel for the bank happily offset 60 million Uganda shillings and retain it as his or her legal costs of recovery? Both the High Court and the Court of Appeal have answered with a no. And the no is based on the law. The law is the advocates, the formula for remunerating advocates is provided for in the Advocates Act and the regulations thereunder. And therefore, can the bank and its external counsel arbitrarily agree to what the borrower shall pay without the borrower's input? And both the High Court and the Court of Appeal have said no, in light of sections especially 50 and 51 of the Advocates Act. Counsel for banks will do well to remember that agreements for payment by way of a percentage in contentious matters are outlawed by the Advocates Act. So if a matter is contentious, the percentage which counsel wants to recover from the borrower can only be recovered with consent of the borrower. I wonder how many borrowers are going to give that consent, but well, the issue is quite simple. The law must be followed in determining how much counsel can be paid on a successful recovery from a borrower in default. So obviously this is not going to go away, and that's why I think it's important. Banks must pay close attention to it, external counsel must pay attention to it, borrowers must pay attention to this. It's quite important. And therefore, secondly, the Court of Appeal upholding the position that service level agreements between the bank and external counsel must be prepared in strict compliance with sections 50 and 51 of the Advocates Act, and non-compliance renders those agreements illegal. So at the heart of the dispute in this matter is a service level agreement guaranteeing a percentage on the amounts recovered from the borrower. And the court saying no, that percentage is unlawful. It violates the Advocates Act. And therefore, the banks and the external counsel will probably have to go back to the drawing board to see what they want to do. Maybe the banks should share some of their interest with external counsel instead and have a safer agreement. Not that I'm suggesting that the banks should get naughty and then have funny exaggerated interest because they're trying to defray the costs of counsel, as I know occasionally happens. But this is something that is worth thinking about. And therefore, thirdly, related to the 2 points above, the extent to which a bank may debit a customer's loan account for recovery expenses is limited. Again, this is to do with the costs of recovery. The collateral has been realized. The bank has gotten back its money. The auctioneer needs to be paid. External counsel needs to be paid. Who sets those fees of the auctioneer and external counsel? Can they be set by the agreement between the bank and its auctioneer and its external counsel to the exclusion of the borrower? The courts are saying no, not at all. And maybe justifiably so. It's a debate that can go on. But in terms of the law, banks need to look at this decision more carefully. Otherwise, some borrowers, after they have paid and they have gone home, they can always sue to recover the excess monies that were defrayed by the bank to cover so-called recovery expenses. So, as I've indicated, I'm aware of this decision, that's Barclays Bank of Uganda versus Gulf View Inn, is on its way to the Supreme Court. But these points have more or less been upheld by 2 courts. We will see what the Supreme Court will decide. But obviously, we'll do well to take note of them. And then another decision, again touching the whole question of closed banks. As we know, we have had quite a bit of there's quite a bit of litigation still making its way in the courts of law regarding the powers of the central bank under the Financial Institutions Act in closing, taking over, and transferring assets of banks. That is one area that remains subject of debate. But in this particular context of Crane Bank in receivership versus Sudiru Paleri and 2 others, the question here had to do with interpretation of the powers of a receiver presiding over a bank under the Financial Institutions Act. Can a receiver file a suit? The answer from the courts of law being no. And the High Court, essentially the Court of Appeal upheld the decision of the High Court. And there is no appeal to the Supreme Court. There was an appeal which was withdrawn. So we can take this as the final position of the law in this context. Being that the central bank, that's Bank of Uganda, as a statutory manager of a closed bank, or as a duly appointed liquidator, has powers to institute litigation in the name of the bank. Okay? A statutory manager or an appointed liquidator can sue in the name of the bank. But the Financial Institutions Act does not envisage a receiver also having powers to sue in the name of the bank. And there we go. What the import of this decision, meaning that Crane Bank in receivership could not sue its shareholders for various breaches and for monies to be refunded and all. The High Court ruled there was no longer standing on the part of Crane Bank in receivership. The Court of Appeal agreed, and prospective appeal to the Supreme Court was subsequently withdrawn. So what we have here is the final position of the law in that regard. it's also something that can always be debated, whether a receiver should have powers to execute suits. Well, the spirit of the Financial Institutions Act really is that a receivership should be very brief, because the decision must be made. You are either closing the bank and taking it into liquidation, or you are transferring its assets to another institution. And I think, so this may make a bit of sense. There may be good arguments, either side of the argument. I'm not taking any. There may still be good arguments on either side of this. But the question is, a receivership needs to be upgraded as quickly as possible if the central bank has chosen to take action. So a receivership should either be upgraded to a liquidation or a transfer of assets. And once one of the two have happened, any litigation should only be conducted in that ambit or by the central bank itself. That's the effect of the decision in Crane Bank in receivership versus Di Ruparelli and two others. Then we shall turn to the Constitutional Court. The Constitutional Court has had a number of interesting decisions for the banking sector. And we shall start with the one which I know the bankers must have been extremely excited to get, and the Council for Borrowers must be extremely annoyed with. The Constitutional Court upheld the validity of Regulation 13 of the mortgage regulations. That is the regulation that requires a deposit of 30% of the first sale value of mortgaged property or an outstanding amount for a borrower to be able to postpone a sale by public auction. Regulation 13, sub-regulation 1 of the mortgage regulations of 2012, was obviously put in place after an outcry that sometimes borrowers in default, sometimes or all the time, the bankers will probably say all the time, but maybe it's not all the time. There's this idea that borrowers want to buy time using the court system. Because you advertise my property for sale, I run to the High Court, I get an injunction stopping the sale, and then after that, I go home and sleep. I may not even fix the main case for hearing. And if the judge has a large docket and the judge doesn't pay sufficient attention, some people used to spend 4 years hiding behind an injunction. They are not servicing the loan. The advert for selling there is an injunction stopping any possible realization of the collateral. So what does the bank do? What does the lender do? And so Regulation 13 of the mortgage regulation was enacted partly to provide some sort of also a middle ground to ensure that both the borrower and the bank are not giving each other a raw deal. The regulation so technically requires that an injunction that is trying to stop a sale will only take effect if the borrower is going to pay 30% of the first sale value of the mortgage property or of the outstanding amount. So if the bank is trying to recover 1 billion and has advertised a property whose first sale value is 800 million or is 1.2 billion, the borrower is going to look for 360 million and deposit it before the injunction can take effect. In default, the bank is free to go ahead and realize the collateral. That's the purpose of that regulation. So there was a bit of debate that this regulation violates the Constitution, the right to access justice, the right to access courts of law. An analogy was drawn in this constitutional petition with the provision, the popular rule in the tax system known as the pay now, adjure later rule. As you know, before a taxpayer is required, before lodging an objection in the tax appeals tribunal, to pay 30% of the disputed tax before they can even have their day before the tribunal. And so it appears the bankers drew some analogy here, and they also did successful lobbying to have this regulation. And so the petitioner in this case, Funds Root Engineering Services and in other verses, Attorney General and Abusa Bank, the petitioner was complaining that this regulation limits access to justice. And the Constitutional Court justices unanimously, the entire 5 of them, ruled that it's not the case, because this regulation leaves room for the borrower with options. The borrower is allowed to go to court and the borrower is allowed to be heard, only that the orders which can be made are those which the regulation is mitigating a little bit to ensure that they are fair to both sides. And in fact, the Court of Appeal also looks at some of the decisions in this area. For example, there was Ganafa South versus DFCU Bank, Civil Appeal number 54 2016, where the Court of Appeal ruled that an order of temporary injunction stopping an intended sale of mortgaged property cannot be granted to an applicant who is in breach of Regulation 13. In other words, if the applicant does not have the 30% to pay, 30% of the value of the mortgaged property, of the first sale value of the mortgaged property, or 30% of the outstanding amount, then no injunction should be granted. That's what the Court of Appeal decided in that matter, Ganafa Peter South versus DFCU. And so the Constitutional Court was saying this is fine. It means that Peter South was actually heard. He was given a hearing, and after the hearing, they told him, look, we have heard you. We shall give you the injunction, but you need to provide 30% of the value of this property, of the first sale value of this property. Or at least give us 30% of the outstanding amount, whichever is lower. And so the Constitutional Court distinguished these two decisions from the pay now, adjure later rule in the Tax Procedure Code and the Tax Appeals Tribunal, which is a bit different because there a taxpayer cannot be heard at all before they have paid the 30%. But the Constitutional Court distinguished that and said within this mortgage regulation, the borrower is heard, but the remedies that can be given to the borrower are those that are a bit limited by this regulation. And the Constitutional Court adopts the reasoning of Justice Stephen Mubiru in Housing Finance Bank versus Silk Events, that this regulation 13 is basically trying to strike a balance between the competing desire by the mortgagee to realize a security upon default and the mortgagee's desire to have his day in court on questions of legality of the process. So, this is an area, obviously, that provided some relief to the banks. Otherwise, if Regulation 13 had been wiped away, a number of borrowers in default would be excited and maybe people would be running to court. There seems to be, from my observation of the court causes and all, people are no longer anxious on running to court because when you tell the borrower that, by the way, the injunction, have you prepared the 30%? Some borrowers will think twice and look for, and maybe go back to the bank to negotiate. And then another important decision, leaving the 30% rule for mortgagors. Another important decision, AB from the Constitutional Court, which also should provide some relief to the banking sector. As I told you at the start, the banking sector is always winning. ABC Capital Bank and 30 others versus Attorney General and Commissioner General URA, Constitutional Petition 14 of 2018. And the Constitutional Court ruled that the taxpayers' constitutional right to privacy of their banking information cannot be violated, even by the taxman. What do we have here? Just to give some background, a few years ago, the Uganda Revenue Authority Commissioner General wrote letters to the banks asking them to provide accounting information of all the account holders for 2 years. Imagine banks being asked to provide to URA the bank statements of all their clients. This was quite onerous to begin with. Of all their clients, so that URA is able to tell that, John has 2 billion in his bank accounts, but he's paying 10 million shillings every year as income tax. So we now need to know that John needs to be pursued. So obviously, the taxpayers, the tax authority wants to have as much information as they can, and the powers of the Commissioner General, the powers of URA to require that information are provided for under sections 41 and 42 of the Tax Procedure Code Act. This petition, in fact, by the banks wanted these provisions, sections 41 and 42 of the Tax Procedure Code, to be declared unconstitutional. But the court refused. The court simply ruled that those provisions remain. However, the Commissioner General and his officers should respect the right to privacy of taxpayers, and when they are exercising powers of investigation, an investigation in a tax matter should be based on reasonable grounds or probable cause to avoid offending the right to privacy. In other words, URA is free, for instance, to write to the bank and say, we need the bank information of so and so. But they should do so, one, on reasonable grounds and probable cause, in order to avoid an intrusive investigation that will be offending the right to privacy under Article 27 of the Constitution. And therefore, the import of this decision was that Uganda Revenue Authority cannot make a blanket demand to the commercial banks, to the lenders and whoever, asking for information about all bank account holders. That would be a violation of Article 27. That is the import of this decision. And similarly, they cannot simply ask for information of an individual taxpayer when they do not have a reasonable or probable cause. It should exist. For example, if there is an ongoing tax audit of a particular taxpayer, they obviously can ask for that information and the banks have an obligation to provide it. But if there is no investigation, in other words, URA is also prohibited from going on a fishing expedition in looking for banking information of customers. They must have reasonable or probable cause to target a particular taxpayer who should be subject of a tax investigation before such information can be availed to them by the banks. That's the gist of this decision. It's important to note that, in fact, by the time the decision was delivered, the demand by Uganda Revenue Authority to the banks had been withdrawn, but obviously the petition couldn't go away because it was an issue that could still probably arise in the future. So this decision provides important clarity on when the banker can provide bank information or not. Maybe the bankers also need to be thinking about the Financial Intelligence Authority in light of this decision and how information can be collected and provided to the Financial Intelligence Authority. That's what I would think. It's not subject of this, but I imagine it is a logical consequence of this decision. And then, well, we have also had, like I've indicated, the subject of bank closures continues to generate a lot of litigation that's working its way in the system. Maybe one time we shall simply have a dedicated discussion on bank closures and what a central bank should do, what it shouldn't do, what are the rights of these bank owners. I'm a shareholder in a bank, the bank is closed. I know for sure that all the depositors who had money in the bank have gotten their money. We don't owe anybody a coin. Shouldn't the central bank account to me at the end of the day? They closed me because I'm not sufficiently capitalized. I can't afford the 150 billion. But at least I was running my small bank well and I paid off everyone. No one has lost their money. Shouldn't the central bank be accountable to me at the end of the day after they have closed me? It's a question that is not going to go away. There is still a bit of litigation from a number of shareholders of closed banks who are asking questions. And I think this decision, though it goes in favor of the central bank, it has a bit of a subtle warning to the central bank that they need to think about carefully. In Humphrey Nzei versus Bank of Uganda and Attorney General, constitutional petition 44 of 2012, which was decided in 2020, it spent 8 years to be decided. Not a good thing. With a 4-1 majority, the Constitutional Court ruled that the provisions of the Financial Institutions Act on closure of banks, which give the central bank unlimited powers to manage a close-out process of a bank, do not offend the Constitution. But they added that the majority added disqualifier that, however, in the future there may be a scenario where the process and manner of winding up a bank may be done unconstitutionally. I think that statement is a signal that the central bank should be careful and be mindful that they are not above scrutiny and constitutional challenges in the future on how they manage bank closures. The Constitutional Court rules that the powers that allow them to sell, in fact, in this particular case, there was a complaint that, our bank was closed and sold within 1 day. And the justices say, well, even selling you within 1 day may actually be lawful because the regulator may have to act quickly to avert a systemic failure in the financial system or to give confidence to the banking public. In other words, the court recognizes that the central bank should not be saddled with a lot of due process that may make it impossible to arrest a failing financial institution and restore order, protect depositors' money, maintain faith and integrity of the financial system. Because of that, the Financial Institutions Act has given leeway to the central bank, to Bank of Uganda, to take action. However, what the Constitutional Court is saying is that leeway should not be abused. It should not be abused to close banks and not account to shareholders, for instance. And in this particular case, in fact, the petition was dismissed. But partly, the reasons for dismissal include the fact that the petitioner didn't provide sufficient proof of the particular actions that were unconstitutional in the process of the closure of the National Bank of Commerce. So maybe tomorrow another petitioner may provide robust evidence that could persuade the justices to take a different view. So obviously, this is an important petition, both from the perspective of the central bank and from the perspective of shareholders of closed banks. And then from there, we'll move finally to the Supreme Court. As we wind up, obviously, there has been so much debate about this decision that I think I'm flogging a dead horse. But well, for the few who may not have had any discussions about it, I will just summarize it quickly. Ham Enterprises and two others versus Diamond Trust Bank Uganda and Diamond Trust Bank Kenya. The justices of the Supreme Court unanimously ruled that syndicated lending, which involves foreign banks, does not contravene the Financial Institutions Act. As you may recall, there was an outcry in the banking sector that the High Court decision relating to this matter had outlawed syndicated lending, or Uganda even made global news that a judge of the High Court had outlawed syndicated lending. The parties continue to disagree that was not the case. But anyway, this decision, the Supreme Court upheld the decision of the Court of Appeal as well. But the Supreme Court extensively deals with this question of syndicated lending and rests it, essentially holding that foreign banks can actually collaborate with local banks in Uganda to do a syndicated lending, and it does not offend the Financial Institutions Act. Obviously, there are so many considerations that go into such a decision, but in terms of the law, we can say it is sound and it's a final position. So banks were given very urgent comfort in this context, that they can continue doing business as they deem fit, especially since most of the bulk of the banks in the country are really subsidiaries whose headquarters are elsewhere, and typically arrangement of large loans, $10 million, $15 million, requires usually to syndicate with the head office. And so it was important that the Supreme Court rules in this matter quickly and provides some assurance to the banking sector that it is lawful for them to continue their arrangements. And they also add in that, by the way, a Ugandan can go and borrow money from JP Morgan, can go and borrow $100 million from JP Morgan. That's not unlawful. A Ugandan can go to Diamond Trust Bank Kenya and borrow. That's not unlawful. A Ugandan business can go and borrow money from the United States, from South Africa, from these larger economies. That arrangement is not unlawful, and therefore the Apex Court essentially ruling that foreign financial institutions can extend credit facilities to financial institutions or persons in Uganda. That's the long and short of this decision. And like I've indicated, I won't say so much about it. I know it's been discussed extensively in various platforms. I think I facilitated one of them earlier after the delivery of this decision. Maybe one other last decision, which I think is also a bit important. Formula feeds. Formula feeds and others versus KCB Bank, which was also decided a few weeks ago. I think it was inadvertently omitted from the presentation, but in the presentation it's saturated. It's also discussed. Formula feeds and others versus KCB Bank. This decision deals with a unique point of view. The Supreme Court and the Court of Appeal, I think, and the High Court, all of them taking the view that merely because a mortgage deed has been found to be illegal or invalid, it does not mean that the root of the credit transaction, the entire credit facility, is affected. In other words, if a mortgage deed is invalidated, it doesn't mean that the borrower, has now escaped liability for the loan. The Supreme Court rules that that's not the case. In the context of this case, that is Formula Feeds and 3 others versus KCB Bank, Supreme Court Civil Appeal number 13 of 2020, what was at stake were personal guarantees of the directors. The directors were arguing that since the mortgage has been invalidated, even our personal guarantees fall by the wayside. And the Supreme Court and the Court of Appeal said, no, not at all. The personal guarantees are a separate security. They are independent of the mortgage. The mortgage is invalid, yes, too bad for the bank, but the personal guarantees remain valid and the directors must pay up. Obviously, this also gives caution, especially to external counsel who prepare security documentation for the banks. Please be careful combining too many things in one document. A different judge may give a different view. Typically, the mortgage deed obviously is separate, the personal guarantee is separate. But again, I know some facilities combine all of these into one document. It could cause trouble. But well, the decision here is all of these were separate and independent contracts, and they don't affect the root of the credit facility between the bank and the borrowers. But I would, if I were a bank, I would be a little more careful and make sure my documentation for credit facilities is as separate as much as possible. I have my loan agreement, have my mortgage deed, have my personal guarantees, and the 3 are separate, and don't keep making too much cross reference to each other. Because in this particular case, the mortgage deed was found to be void. But the personal guarantees were held to be enforceable, and the principal loan agreement was also held to be enforceable. And so, as I started by saying, the bank won. And when the banks win, to give a comfort to those who are not happy with the banks winning, when the banks win, the financial system wins. When the financial system wins, we have a strong economy. When we have a strong economy, we all win. The 3 are related. When we have an economy where recovery of loaned amounts is very difficult, then we don't attract capital into the country. When we don't attract capital into the country, how are we going to develop? We need the dollars into the economy, because we literally we import almost so many things. So the cost of credit is affected by the decisions in the courts of law, and maybe that's why the courts of law are also go out of their way to try to protect the rights of banks. And you'll see the jurisprudence created. Is very lenient towards the banking sector in many respects. It's very lenient towards the regulator, the central bank, in many respects. But it doesn't mean that it has been that way throughout. I've just made a sample. We also have decisions, obviously, of banks being held liable for selling properties below forced sale value. Those are simple things which should be obvious. That is fraud on part of bankers when it happens. If a property is not sold in accordance with the law. So, for the borrower's comfort, the decision I picked out to remind the borrowers about their rights, Barclays Bank Gulf View In, which is still making its way in the Supreme Court, but it also gives a warning shot to the banks that they need to be careful how they conduct recovery processes. They need to be a little more careful how they debit borrowers' accounts in the name of recovery expenses after a collateral has been realized. But that's a snapshot of recent decisions touching the banking sector. I thank you very much. and I'm available for any comments, questions, disagreements, and all for us to enlighten each other in this area.
Wow.
It's about Section 28 of the Mortgage Act. The position of the judge in that matter, the position taken by the High Court, is at what is the point at which a collateral is being realized. That should be the point at which consent is given by the mortgagor to either proceed by way of private treaty or by public auction. I know the banks are not happy about it. So this is one of those other decisions that is trying to protect borrowers. Because the question is, I can understand why this makes sense. You make a mortgage deed in 2020. That's why in the mortgage, both the Mortgage Act and regulations still require, for example, that when an advert must be run afresh, even in public auctions, and that a property must be valued 6 months before. Is it 6 months before a sale? All those are inbuilt to provide some layer of protection for mortgagors as well. The mortgagee needs to recover. The mortgagee needs to recover their money. But again, the mortgagor should be protected, given some level of protection. That's the spirit, I think, even of the judgment. And I don't know whether this matter was appealed. It doesn't look to have been appealed from my little investigation. Obviously, I can sympathize with the bankers and the people who are in recovery. Because, like I mentioned, there is hardly any borrower who is going to allow a sale by private treaty, except those unusual cases of a borrower saying, look, price for the property. A better price for the property means the mortgagee gets back their money, but the mortgagor maybe takes something home as well. This idea that the mortgagee should recover their money and they don't care what else they are getting can be very problematic. I have litigated one matter, which maybe I left it out here because of that conflict. Is it conflict of interest? It's not necessarily a conflict of interest, but I think it's reported. And permitting the mortgagee to realize a security by way of private treaty, several years after a mortgage deed was executed, in my personal view, it does not necessarily always bring the best price. Private treaty almost always fetches the poorest price for a property. And so, speaking from the perspective of borrowers, of the borrower, I know the banks are saying a private treaty will be easier for me because then, after all, I'm a bank. I know who has the largest bank balance. I can ring them and say, by the way, I have a property here. Why don't you come and we talk? There's that tendency, fair enough. But you know, the bank can still say, by the way, we are running an advert for this property. Think about it. There's still a way around it on the part of the bankers. But the borrowers have no recourse. The mortgagor has no recourse. If a property has a market value of 1 billion and it is sold by private treaty for 300 million shillings, it's going to cause a lot of trouble and risk also to the bank. And that's what I would say in regard to that comment.
Yeah, thank you for that, Jude. I think you still have a comment from Dorothy Masifa Ochola. Dorothy is also a seasoned banking lawyer, and she does agree to some extent that the focus should rather be on, has someone borrowed the money, do they have the capacity to pay back or not, other than these other considerations that we seem to be focused on for different borrowers. And she does mention that in some jurisdictions that's what the courts have focused on. She applauds the courts for having seemed to take that direction for now, at least. And you have another comment from Patricia Kemirembe, and she says there's no practicality on securing a borrower's consent to the lawyer's fees at the time of recovering a loan or for foreclosure. And
maybe I can respond to that.
Yeah, sure.
When it comes to lawyers' fees, what I think in-house counsel for banks need to understand, and the people who procure services of external counsel, we have a law that regulates how much lawyers should be paid for different kinds of services. Anytime that payments are made to external counsel, which are in violation of the advocate's remuneration and taxation of costs regulations, it will always leave the bank vulnerable. And I'm not sure the bank is going to ask external counsel to refund that money when they have an SLA that provides that framework already. I think what the bankers need to do, our colleagues in the bank who are in-house who prepare these SLAs for their external counsel, they need to be mindful of the provisions of the Advocates Act. The advocate, if the problem is the Advocates Act, banks, I believe, have sufficient clout to ask for the Advocates Act to be amended to protect their external counsel. I also don't want a situation where I have an SLA with a bank that permits me to recover 10% on whatever amount I recover from a borrower in default. And then after I bring in 3 billion and I want to take my 300 million, they start telling me about the Advocates Act, giving me a lesser figure. I wouldn't want to listen to that. And I believe that is the sentiment that underpins the dispute in the Gulf View in Barclays Bank. That is the sentiment. I have an SLA, it permits me to recover this much. Why not? And I have done the recovery. I can't do the recovery, then at the point of recovery, you suddenly want to pay me less. I would not agree as well. So bankers need to think about a better formula for remunerating external counsel. I know debt recovery is hard work. People need to be paid well for debt recovery. No question about that. But again, if I'm speaking as counsel for a borrower, I'm also going to say I don't want my borrower client, it's bad enough he has defaulted. But that should not be an excuse to subject him to predatory cuts on his loan account. And then I start learning that, 200 million has been taken to pay legal fees for the auctioneers and external counsel. If I'm acting for a borrower, my initial instinct is going to be, is that permitted by the Advocates Act, that external counsel gets 200 million? And if it's not, I'm going to think about a litigation. How do we avoid that? Banks, external counsel should sit down, make sure their SLAs are compliant with the Advocates Act. If the money is payable under the Advocates Act are quite low, which I believe they are quite low, then banks should work out a better formula. They should work out a better formula that does not run afoul of the Advocates Act for remunerating their external counsel.
There you have it. I think this is an issue that is quite central to us as banking lawyers, and maybe better take the heed to look at the Advocates Act ahead of getting into agreements with different banking clients to avoid that possibility. Jude, I want to draw you into a conversation of cryptocurrency, and I noticed that Dorothy has already made a comment about it in the Q&A tab, and she says that, does the banking industry intend to engage the central bank on the use of electronic means of payment, including cryptocurrency? The world is moving fast, and it's an emerging trend that cannot be ignored. She goes on to say, risks are a way of life and need to be foreseen, prepared for, and mitigated. It's not good practice to avoid risks, so she thinks the earlier this is looked into, the better. And precisely because we represented Silva Kayondo, I hope I'm also not conflicted speaking about a matter which we have participated in as metrics advocates. In this case against BOU, and we did have a conversation with our client post-judgment. Maybe we felt that some of the aspects in our application could have been held better, especially regarding the constitutionality, rather the legality of cryptocurrency. For starters, we hadn't included that in our application for court to rule on the legality or illegality of cryptocurrency. But also, if you look at the general spirit of the National Payments Systems Act, it does encourage a lot of electronic transactions, electronic payments, and it really defeats the purpose that you would now be regulating against cryptocurrency, which is likely the next big thing, perhaps already a big thing, because there are already players in the cryptocurrency market in Uganda. And so some of these, we are going to be talking to Silver to see if we can possibly appeal this this ruling on cryptocurrency. But what are your thoughts, Jude? Is this something we should shy away from, or it's a reality that we should deal with?
Cryptocurrency is not going to go away, that's for sure. It's not going to go away. The manner in which cryptocurrencies are regulated will probably continue to change. Like I stated earlier when we were discussing this point, technology and innovation generally go ahead of the law. The law follows them, not the other way around. Okay. Now, many central banks obviously are skeptical of cryptocurrencies because you have to recall that the whole model of cryptocurrencies is in fact to try to get rid of the regulator. Okay? And so naturally, the regulator approaches the whole concept of cryptocurrencies with suspicion, skepticism, and hostility. Because if I'm a regulator and you are trying to come up with innovations whose purpose is to render my work obsolete and make it hard for me to do my work, I'm afraid, but I'm not going to approach you with a lot of interest and enthusiasm. That's a natural thing for really all central banks globally. That's the issue with cryptocurrencies. It should also not be forgotten that cryptocurrencies are also used to facilitate crime and are also used in terrorism financing. That again creates room for caution. So central banks may not outrightly want to encourage cryptocurrencies, but I don't think they'll go away. Cryptocurrencies are not going to go away. The manner and mode in which they are regulated will probably change. And probably if the innovators found a role for central banks in cryptocurrencies that makes it a little easier to control them, there would be some discussion. But again, the people creating cryptocurrencies also have their view that they want the state and state institutions to have as little role of a medium in the use of cryptocurrencies as possible. That's the sentiment as well. And maybe that is why it is easier for cryptocurrencies, for example, to be used for illegal activity like terrorism financing, for crime, for people who are demanding for payment of ransoms who don't want to leave a trace. That forms the basis in which a bit of skepticism and hostility arises. But I think we just have to, it's still early days. Cryptocurrencies are not going to go away, and we have to just continue to watch and see how they are regulated. That having been said, I think it's not a very wise strategy to try to use the courts of law to create a legal framework that does not exist. I think it was a bit of a dangerous strategy, maybe, for Silver Kayondo to try to get a declaration to use to recognize cryptocurrency from the courts of law. Any prudent judge will not give it. Why? Courts of law generally should not try to create policy. And I generally subscribe to the school of thought that courts of law, their job is to adjudicate disputes. Creating the law, creating policy is a matter for parliament. It's a matter for the lawmakers. And therefore, it's dangerous to try to use creative litigation to get a court of law to give legal recognition to cryptocurrency when the regulator is shying away from that. So I probably think we have to be careful in how we use litigation and to what end. Because again, the problem now, the setback that gets suffered from a ruling like that one of Silver Kayondo Bank of Uganda is that it emboldens Bank of Uganda to say, the court has agreed with us that cryptocurrency can even be outlawed. Maybe it is better to live an ambivalent environment so that to give room to the central banks to see how the extent to which they are going to tolerate cryptocurrency. I remember when mobile money had just started, there are people who would not accept to be paid mobile money because they wanted to be paid in cash. They didn't want to be paid by mobile money. But now I think no one still says, please, I need my cash. I don't want those mobile money things of yours. It's about technology. It's about innovation. Innovation and technology generally will always move ahead of the law. By the time we are thinking about a legal framework, by the time we are thinking about proper policies, there must be enough experience. Because ours is a financial sector that's very young, typically we learn from major economies and what they are doing, and then we try to tag along and learn from them. So if the major economies are skeptical of cryptocurrencies, it's unlikely and maybe not a good idea for Uganda to try to punch above its weight.
Thank you. There is a lot of debate in the chats. I hope that we can wrap it up very quickly because we are fast running out of time. But I'll briefly just highlight a couple of questions from the chats. There is a Chirungi Barnabas, or Kirungi, I don't know if I pronounce it properly, but Barnabas asks about the implications of the Bank of Uganda Financial Consumer Protection Guidelines and if the same should be adhered and enforced by courts of law. I think the question is if these are law or, and if they are, can they be relied upon by courts of law to adjudicate?
Well, I thought guidelines are guidelines. And actually, one of the decisions, I think, discusses the utility of consumer protection guidelines. One of the decisions which I've indicated, but obviously guidelines can provide a benchmark on which the courts of law can test the conduct of bankers. So the guidelines may not, on themselves, they may not found a cause of action. And indeed, I've seen, I think, all the litigation trying to complain about consumer protection guidelines never goes far. However, a borrower who is aggrieved could probably point out that to violation of consumer protection guidelines as a way of pointing out where the bank may have fallen short in its standard, whether the central bank or commercial banks. But it would obviously be extremely dangerous to try to found a cause of action based on the consumer protection guidelines.
All right, thank you for that clarity. Still a couple of questions, especially around conflict of interest. I think there's a debate going on between Musinguzi, Bernard, and Dora. Musinguzi wonders if they witnessed a loan agreement, a bank loan agreement, would they, as advocates, would they be then barred from taking on recovery services for that particular bank?
I think there's litigation in sector which says witnessing a document in that context cannot bar someone from recovery. It would only be, the problem is it depends on the nature of the form, because that is a general thing. Is it the independent advice form? Obviously, that's quite different. An independent advice form is obviously a different thing altogether. If you are a banker and your borrowers come to you and you send them to external counsel and they pick one of the advocates in the firm to sign on that independent advice form, and then tomorrow you are sending them instructions, it does mean that this was not an independent advisor and you could be causing unnecessary risks for your enforcement process for no good reason. So you'd rather, if the borrower needs an independent advisor, you'd rather tell them when they are coming to sign off documents and tell them, please come with your lawyer to sign off and we get this done. But from my experience in this area, it's also, I think, a bit of a joke that borrowers will never read mortgage and loan documentation at the point of signing and getting the money. But when there is a dispute, they will read every small letter that exists. And that's, but also bankers, I think, when they are excited, we are now closing this, they forget about those nitty-gritties of independent advice. Who is this? And the excitement may be, but we have our lawyer. Come and sign this independent advice form. And the lawyer is on the border and signs, and the borrower, the documentation is complete, and the funds are disbursed. And then after the funds have not been used properly, or efficiently, as Mr. Tim was guiding us, then problems arise. And that's when people remember that they need to study their own documentation properly. I think I've been involved in litigation before where a mortgage deed was not even, I think, signed by the part of the borrower. Or some of the loan documentation, there are two directors, only one director has signed, the other hasn't signed. Funds already disbursed and used. So it's extremely important for the bankers to pay very close attention to the manner in which documentation is concluded. That's why I cited that case of formula feeds and others versus the KCB Bank, the Supreme Court decision, where the mortgage deed was found to be invalid. And because, well, that leaves the director's personal guarantees exposed. But what if I'm a director and I know my collateral has been saved? You can't realize it. I may go and chill in DRC or South Sudan for a couple of months, and you won't find me. Although, of course, the banks can still recover in the context of the facts of that case. It means the collateral can only be realized now as an independent property of a director, which can be attached in a normal using the normal judgment, date, and execution process, but not as a collateral which they are realizing. So you forget about the Mortgage Act and regulations. You forget about 30%. You forget about adverts under the Mortgage Act. It's a whole new animal when you have to attach a property. And now the borrower has so many tools at their disposal to frustrate the whole arrangement.
Thank you for that clarification, Councillor Jude. I'm afraid our time is fast spent. I know that there is a lot more questions that will be coming through, but please keep them coming through. We'll have a way to address them, perhaps through your emails, or later contact you personally through your chats and answer to these questions. But we do thank you very much for having been part of this symposium since yesterday up to today. I know there's a couple of members who have attended both sessions, and we're very grateful. We're also grateful to our panelists, and I would like to mention them out here. The panelists who facilitated in the first program that we had yesterday, that is Mr. Emmanuel Pateka, the head legal Postbank, Agatha Nisima, a partner at Viencha and Chihika and Company Advocates, Ian Mutibwa, the managing partner at Signum Advocates, Miss Anna Kakuba Nanziri, who is a tax manager at BDO. And today we have been having, obviously, Mr. Jude Byamukama, who is the managing partner at J. Byamukama and Company Advocates. We have had Mr. Innocent Damurira, who is still with us, by the way, a partner at DIT Advocates. We've had Mr. Ahmed Senkumba, who is the head legal and compliance at Bank of Baroda. And we have had also Mr. George Jeto Otim, the manager corporate finance at BDO East Africa. We'd also like to extend our thanks to the Uganda Law Society executive for facilitating us to hold this symposium, and we do hope to hold many more events as the banking law cluster. We also cannot forget to extend our gratitude to the Uganda Bankers Institute, who have hosted us for purposes of live streaming. My name is Keith Namara Charuzi, who has been your host, a partner at Matrix Advocates. It is a pleasure to have had you for these 2 days. We look forward to have you again next year. Thank you very much, and good evening.